My lord, under compelling
1
circumstances.
day left, what will happen? Yes, what is the mention?
My lord, under compelling circumstances, my lord, I am praying for your lordship's kind leave to move on matter, my lord, urgently within short service, my lord.
What is
If your
urgency?
lordship, my lord, the difficulty is, it is a tender matter. My bid has been rejected. There is a bona fide mistake. If the mistake is corrected, my lord, the government will gain by 15 crore for the tender period, my lord. The government has rejected. Or she will kindly consider any time, my lord.
No
Today,
time
tomorrow,
left. No.
my lord,
There are so many
the
matters
letter of
already fixed.
my lord, letter of acceptance will be issued.
Maybe.
My lordship kindly
Will abide
consider.
by the result. No.
Kindly consider. My lord. I am beseeching your lordship.
No, no. Mention before the vacation bench. Yes.
License under the Excise Act has been by not withdrawn on the ground I have not applied for the change of management. Though I have applied in May 2023, only that not was 10 employees are working.
After the vacation, Mr.
Consider.
No.
Otherwise, they will not.
No, Mr. There are too many matters. Yes.
On the ground of urgency that already suspended and government invested competence fund and already suspended, and for that reason other tender also.
No, no. File it in due course. It will appear in due course after the vacation.
Pilot,
Not before vacation. No, 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 no leave is to be granted. I understand, but no leave can be granted. Yes.
Lordship, item number 96 of 196 of today's with Lordship, Excise Authority immediately closed my shop. The shop is running since 1921. Many
I'll take up after the vacation. I'll take up after the vacation. Yes.
Your lordship leave my lord to move the matter before the vacation bench, my lord.
No, no. Mention before the vacation bench. Yes.
My lord,
Mention
I'm
before the vacation.
giving my prayer. I am beseeching, my lord. It will be extremely difficult. Lordship, kindly takes up.
I've
Tomorrow,
refused
any
immediate
time,
prayers. No, not possible. The other upgrade matters, let me take up those. Yes, Mr.
My lord, I am praying leave
No,
to
tomorrow,
move
my
the
lord.
matter before the vacation bench, my lord. It's a tender matter, my lord.
Vacation bench, move before the vacation bench.
Not made be
Yes.
taken up tomorrow, my lord.
No.
Kindly, Lordship, kindly.
File it in due course. No.
Lord, leave to file review application without certified copy, my lord. We have applied for certified copy, my lord. We are annexing the web.
Leave is granted.
Great. Great.
Your lordship may be permitted to mention to matters, your lordship.
No, no mentioning.
Lordship, may I pray even to leave even to Lordship.
Jalpaiguri matter.
Lordship, may I pray even to leave
Jalpaiguri
even to
matter
Lordship
for
to file
judgment
this
item
even to
number
read
1
petition.
and 2.
Lordship, without certified copy of the order,
Accordingly,
even to Lordship.
thus the writ petition is not maintainable at the instance of the writ petitioner on the ground of lack of locus standi. Accordingly, WPA 2209 of 2021 with CAN 1 of 2022 is dismissed on contest. WPA 1168 of 2022 is disposed of accordingly in the light of the above observations.
Lordship, I'm praying even to Lordship, kindly grant me leave even to file this even to read petition without certified even to copy of the order passed by the National Green Tribunal even to Lordship.
Yes.
Appellate side to be mentioned. Item number 1 for non-prosecution.
My application, my lord.
Non-prosecution?
My lord, non-prosecution. My lord, only indulgence, my lord, to file afresh, my lord, if your lordship.
Why? What is the difficulty? Why?
My lord, MSME is the party to this proceeding.
Achha.
MSME, the petitioner made a representation.
So this is not for non-prosecution, for withdrawal with leave to file.
Withdrawing.
Very well. Learned counsel for the petitioner seeks leave to withdraw the writ petition with liberty to sue afresh. Full stop.
My lord.
Accordingly, WPA 505 of 2022 is dismissed as withdrawn with
Fine.
leave to the petitioner to sue afresh on the self-same cause of action.
Fine.
No rest to cost.
Extension of interim order. Item number 2.
My lord, this matter is appearing at our instance.
When does it expire?
My lord, 31st of December 23, my lord. Any day, my lord, in the first week or second week, if
No,
not.
first week, second week.
Very well, I'll leave it to your lordship, my lord.
Learned, the interim order granted earlier is extended till February 15, 2024 or until further order, whichever is earlier. Stop. The matter shall be listed on January 16, 2023 for hearing.
Grateful, my lord.
Next.
Top item. Item 3.
For the statement, last occasion, your lordship directed to submit a report, my lord. The report I have already advanced copy had already been started.
What is your report? What does your report say?
But I have just received the report.
They say that they did not find. Please give a copy of the report to her.
Already advance copy already in
They,
sir.
they say the police say that they did not saw any drug peddling or anything in the area, and that you are also a habitual litigant and you are in a habit of quarreling with other inhabitants.
My lord, I have got many orders and I have even, I mean, police, people have given complaints and police are not taking any action. I'm having those, but
Why are people against you? Because you are protesting regarding the drug peddling, according to you.
No, my lord, what police has made I mean, report, I am not at all agree with it because
Here we cannot investigate the matter. We are not the police, but I can advise direct the police authorities to file another report, an interim report after vacation. What steps they have taken regarding the
My
investigation?
lord, I also want to ask some time because I'm not well since 5 days. I'm having fever, so I've not completed, not able to complete the supplementary also. My lord, and the
Come back after the immediately after the vacation. I'll keep it.
all right, my lord.
An adjournment is sought by the petitioner appearing in person due to her ill health. Push up. The report filed today on behalf of the police authorities be kept on record. Push up. The petitioner is granted liberty to file any exception to the report if she so chooses, comma, on the next returnable date with an advance copy on the learned advocate for the state. Push up. The matter shall next be listed on January 9, 2023 under the heading Upgraded Matters.
My lord, on 9th, I'm having a.
Give me the date.
uh,
10th,
on-
11th?
On 4th, my lord,
No, 4th, first week not possible.
not possible. After 9th, then.
Very good. On 10th, on January 10th, 2024, under the heading Upgraded Matters. If you want to file an exception to this report, please give a copy to them in advance.
Lord,
Yes, well, one thing is application he has been filed only, then they are not served to me.
I haven't. I need some.
When this matter is done, ma'am, please have a talk with your learned friend.
Yes.
Whatever documents are missing, please hand over.
Yes,
Please
Lord.
help her.
Lord.
Immediately now, just tell her which documents are not there. Just sort out and give the copies.
Item 4.
I am appealing for the licensing company. May I be
Madam, for the
permitted
petition.
to file
Yes, Ms. Chakraborty.
report, my lord?
Report.
There is
Acha.
an affidavit
What
of
is the matter about?
Madam, this is the matter relating to new connection, new electricity connection to the premises of the petitioner. The private respondent, my lord, unnecessarily creating harassment or disturbances from
Does the report say?
My lord, report is
the report
and,
says that the
attached with
pathway.
Later.
sketch map, my lord. Sketch map, my lord. Required, my lord, 4 polls, my lord. Now, poll number 1, my lord, is raising objection, my lord.
If objection is, it has to be raised on somebody's land.
Yes, my lord.
It has to be erected on some third person's land.
Yes, my lord.
If that be so, then you have to take recourse under the works of licenses rules. Take a permission from the magistrate. You have to do that. That's your duty under the law. The licensee's duty. I'll direct him to take that permission from the magistrate and do it.
My lord, this is the Panchayat Road.
Your picture says it's in somebody's land.
Yes, my lord. Panchayat Road, my lord.
But my lord, in the report, my lord, the
The
last.
pole has to be erected not on somebody's property.
No, my lord. Panchayat Road.
The last line of the report, my lord.
Ms. Chakraborty, both of us,
Hello.
I cannot hear both of. Please take your seat. Please take your seat.
Joint inspection, my lord, is held on 12th December 2023 at presence of petitioner and private respondent. Chitra Kole, my lord.
You have stated in your report that a way leave is to be obtained from him. Why should a way leave be obtained for erection of a pole on public property? Your report says otherwise. You are submitting verbally that it's on government on
Yes, my lord. Government Panchayat Road, my lord.
Panchayat Road.
Yes, my lord.
But you have stated in paragraph 5 of your report that letter was issued to her stating that the service connection will be effected only if proper way leave. Why should way leave be provided by her if it is on public property?
Last line, my lord, paragraph 6, my lord.
Yes.
The Panchayat Road, my lord. Last line, my lord.
The report filed today be kept on record. Full stop. None appears for the private respondent despite service. Full stop. Next para. The report of the distribution licensee is rather contradictory. Full stop. Although the WBSEDCL has said in the report that the poles which are to be erected to give electricity connection to the petitioner are to be erected on panchayat property, comma, in the same breath, comma, a way-leave certificate has been sought from the petitioner. Full stop. Such way-leave certificate, comma, if the pole is to be erected on public property, comma, is utterly unnecessary, and the WBSETCL could not have insisted upon the same. Full stop. Next para. In any event, comma, under the Works of Licenses Rules 2006, comma, it is the duty of the licensing of the distribution licensee to take appropriate steps if necessary, comma, to give electricity connection to an applicant. Full stop. In such view of the matter, comma, the private respondent's objection cannot be sustained. Full stop. Hence, WPA 23085 of 2023 is allowed, directing the WBSEDCL to give electricity connection to the petitioner, subject to the petitioner complying with all due formalities in that regard, comma, as expeditiously as possible, comma, positively within December 31, 2023. Full stop. Next para. In the event any objection is raised from any quarter, comma, including the private respondent, comma, it will be open to the WBSEDCL personnel to approach respondent number 3, the officer in charge of the Bauria police station, for adequate police assistance. Full stop. If so approached, comma, the Bauria police station shall give such assistance by acting on a server copy of this order at the cost of the petitioner. Full stop. It is made clear that in the event any third party has any subsequent objection after the line is given to the petitioner, comma, it will be open to such parties to approach the appropriate forum in law to thrash out such disputes. No address to cause urgency report.
I'm deeply obliged.
Next.
Item 5.
The bank.
My lord, I beg to appear on behalf of the
What
petitioner.
is the matter? Mr. Lahiri?
Yes.
Yes. What is the matter?
My lord, a loan was taken by the concerned Moushumi Cashew Producers Limited, my lord.
Yes.
A land was mortgaged, my lord. It was declared NPA. The petitioner was the proprietor of that.
Two petitioners, both are
No,
proprietors.
first is the father who is suffering from carcinoma stage, having chemo. So his son has been made petitioner along with him because he is restricted with his movement.
Who is the proprietor, father or son?
Father, the petitioner number 1. My lord, so my lord, it has been declared as NPA, my lord. Now, my lord, order was passed under section 14 by the learned DM. My lord, kindly take page 17 for once. Page 17.
Yes.
My lord, though it is written the date is 11th of March, left hand side, it is 2021, but it is 2022, my lord.
All right.
My lord, kindly see the schedule of property, which was mortgaged for that amount, my lord. Now it is of, kindly take the page number 18. I will not trouble your lordship with the whole issue.
Yes.
My lord, kindly take page number 18, the second paragraph. The authorized officer of the secured creditor not received any representation from the borrower in reply to the demand notice of 13/2 dated 10th of November 2009. It is of 2009, my lord. Now it is being passed in 2022. However, my lord, kindly take the last paragraph. Due to pressure of administrative works, the possession order could not be issued within the stipulated time period from the date of application to this office and on the basis of hearing on 10th February 2021. So which was initiated 2009, it ended in 2022. Now, my lord, I'm not going into that. After that, my lord, I offered the bank that I'm paying you 40 lakhs rupees. Against the outstanding, I'm giving you
What is the total outstanding?
It was 1 crore and odd, 1 crore 7 lakhs and odd. My lord, now I offered 40 lakhs. I paid 20 lakhs. My lord, then the bank remained silent. Kindly take into note, my lord, the bank did not implement or execute the order of the concerned DM. Now, my lord, there was an offer for compromise, which is at page 25. We offered a compromise of rupees 51 lakhs and odd, 51 lakhs and 25,000. That compromise was accepted by the bank and it was sanctioned. My lord, kindly consider my submission.
What is that sanction?
My lord, it is recorded in their bank's order itself. My lord, kindly take page number, my lord, 48 for once. Now, my lord, I kept on paying. I paid 29 lakh rupees. My lord, I'm placing, this is very important, my lord. Cancellation owing to failure of repayment terms of your compromise offer, borrower such and such. We refer to your offer for compromise in the above mentioned account. And our letter such and such dated 7th of September 2022 conveying sanction of compromise settlement for rupees 51 lakhs, 51 crore 25 lakhs. Due date of which was further extended to 30th of April 2023, we observe that you have failed to adhere to the repayment schedule as per the sanction terms and conditions of sanction, and hence the compromise settlement has failed due to default from your side. In view of the same, we were unable to process your request for further extension of time as per your letter dated 5th of July 2023. In view of the above, we would like to inform you that as the above compromise settlement is treated as failed, the bank shall appropriate the amount deposited under the compromise settlement, in this case of 29 lakhs, towards your loan dues as per appropriation policy of the bank. Now, this letter is without prejudice to the bank's right available against you, being the borrower or guarantor, and to initiate such other actions, including action under SABYASACHI Act 2002 or other legal proceedings as the appropriate authority of the bank deems necessary under any other applicable provisions of law. My lord, kindly mark two things. First is that there is a sanction of my compromise. Now there is admitted default because
It has failed.
it has failed. Now, because since I'm not going on to that why, my lord, kindly take the last paragraph, to initiate such other action, including action under SABYASACHI Act 2002. Now, my lord, kindly take the next page 49.
Yes.
That is the notice issued by the police. It's an undated notice that today at 11 a.m. they are going to take possession with the bank.
When did you receive it?
My lord, I received on 18th night. My lord, there is no date, however it has been given to me. My lord, kindly take the reference order of the district magistrate Purbo Medinipur dated 11th March 2022. Now, my lord, my submission is this. The order of DM, my lord, I do not challenge it because I have to challenge it before the DRT. My lord, admittedly, there is an order. Now, the bank by its act and conduct has deserted that order. It has not executed or implemented. Now they enter into a separate proceeding of compromise. We enter into a separate procedure of compromise, which is not recognized under the SABYASACHI Act. Now, my lord, a parallel and different proceeding has been initiated. That has admittedly failed. Now I said that give me some time, since I'm undergoing cancer treatment. I have made it in the prayer also that give me some time. I will be paying the money by March 2024 within this financial year. That much. I have not said that I will not pay. Now, my lord, my submission on law is that now after deserting the order of the DM, can the bank authority, with the help of the police, after initiation of a separate proceeding according to their discretion, can again come and execute the order of the learned DM, which is not. Because, my lord, my humble submission is this. My lord, may I just, my lord, my humble
For the cancer, I'll give you 3 weeks time to vacate.
3 weeks, my lord, I'm undergoing chemotherapy.
You've already taken sufficient time.
Lordship,
you have already taken sufficient time since 2022. You knew about the order in 2022. So you are under threat of expulsion.
Yes, my humble submission on
already got almost,
no, admittedly, my lord, I do not go on that.
1 3/4 years.
My lord, as per the section, my lord, my humble submission is this. My lord, they cannot now, because they say we will reinitiate SABYASACHI proceeding. They have to reinitiate SABYASACHI proceeding now. If
I'll interpret that.
Well, only one humble submission. There is one judgment, my lord, of the Bombay High Court Division Bench.
Right.
The time limit has been set as 4 weeks to implement the order of the learned DM for that. My lord, if I may hand over.
Yes.
Page 21 of this judgment.
Please give the citation for Mr.
Yes,
Rai
yes.
and
The
Mr.
citation is AS Writ Petition number 15285.
This is an unreported judgment. Then give a copy to them.
This is from the server of the Bombay High Court.
Mr. Rai, unreported judgments, you always have to give a copy.
Yes, I'm handing over copy. My lord.
Do that. You are relying on para 21.
Para 21. My lord, I'm sorry, I'm just handing.
You don't have your own copy also.
My lord, I'm just handing over. My lord, I'm sorry, my junior.
When did you find out while coming to court?
No, my junior could not bring the
para 21.
Yes, my lord. I'm so sorry, my lord.
Find out para 21.
I'm so sorry.
Up to para 20.
No, I'm so sorry, my lord.
No.
I'm so sorry, my lord. I thought it is
because I'm against you, Mr. Lai, against your client, so you have
I'm so sorry, my lord.
full time to satisfy the court.
Yeah, I'm so sorry, my lord. Yes, my lord. Kindly take paragraph 18B.
Right.
I'm so sorry, my lord.
No, that's
I'm so sorry. Because I thought it is with her.
It's 18B.
My lord, my humble submission
This was in favor of the bank, Mr. Lahiri.
Yes, only 4 weeks time to implement the order of the Raned DM.
Does
That-
not become bad after that.
No, I'm not saying that. My lord, I am not challenging that order also. I cannot challenge before your lordship.
No, implementation cannot become barred after that.
No,
That
it
is
is
not what-
not, my lord. If your lordship takes the Honorable Supreme Court's judgment also, I'm embarrassed, my lord.
Why?
My lord, I have the one call. I'm so
Very
sorry.
well. What is the judge? Give me
It
the
says
cite.
that it has to be
What
implemented.
is the citation?
This is, my lord, R.D. Jain and Company versus Capital First Limited. This is a reportable judgment, civil appeal
What
number.
is the proposition there? Just tell
It
me.
says that it has to be implemented immediately. There cannot be any brook of delay after the order is passed by
They are
the
relying on this.
lordship.
They are relying on this.
Yes, I'm also relying on this. It says it has to be implemented, but it has not been implemented. Now they cannot go back after initiating a separate proceeding under their discretion of compromise. Now, once the compromise has been,
The Lahiri, you have tried your level best. Let me pass
my lord,
on.
only one may I make humble, my lord, instead of 3 weeks, kindly, my lord, sometime. He's suffering from cancer and
He
undergoing
has been
chemotherapy.
suffering from cancer for 1 and 3/4 years.
No,
Now, Mr. Lahiri, we have to end it somewhere.
my lord,
I
I'm telling.
appreciate fully
I
sympathize.
undertake, my lord.
But my sympathies cannot go beyond a limit.
No, my lord, I
You have
undertake.
got almost 2 years.
No, it has been detected.
This will never
recently.
end then because
is-
his cancer will remain
Yes,
unless he is cured. We hope
it
he
is
is
not.
cured.
It is not
But
possible.
if it's in such a stage, I mean, it's an advanced stage, I fully sympathize. But that cannot be a ground for
Absolutely,
interdicting
absolutely. My lord, only
forever.
thing is that, my lord,
No.
I've lost money in my treatment. I'm seeking, my lord, 1 month time maybe given. I'm praying before your lord.
Very good. I'll
1 month time.
I'll give you 1 month.
I prayed for 3 months. I pray for 1 month, my lord. If your
Learned
lordship
counsel for the
considers.
petitioner, I've heard you with all of it.
Yes, yes.
Learned counsel for the petitioner submits that, petitioners submit that the petitioner number 1 is suffering from a terminal illness. Petitioner number 2 is his son and has been implemented since the petitioner number 1 is not in a position to properly monitor the litigation. Next para. The petitioner number 1 is the proprietor of a particular concern, which took a loan from the respondent bank, subsequently having failed to repay, the bank obtained an order under section 14 of the SARFAESI Act 2002. The order, it is submitted, was passed as long back as on March 11, 2022. Although it has been misprinted in the order annexed to the writ petition as 11th March 2021. Next para. Subsequently, the petitioner made several offers for settlement of the loan. Initially, an offer of rupees 40 lakh was made. Thereafter, a higher amount was agreed upon. However, the petitioner having failed to meet the terms of the one-time settlement, the bank gave a letter dated August 2, 2023, indicating that the bank would initiate such other action, including action under SARFAESI Act 2002 or other legal proceedings as the appropriate authority of the bank deems necessary. Learned counsel argues that the said communication regarding proposed further action automatically indicates that the bank waived its previous order obtained under section 14. Next para. Learned counsel places reliance on an unreported division bench judgment of the Bombay High Court in L&T Finance Limited versus the state of Maharashtra and others, where inter alia, the division bench observed that every order passed under section 14 of the SARFAESI Act should be implemented and executed not later than 4 weeks of the passing of the order. Next para. Learned counsel also argues that the Supreme Court has observed in certain cases that the orders under section 14 have to be implemented as expeditiously as possible, if possible immediately. Having not been so done, it is argued that the bank cannot now fall back upon the order passed in 2022 under section 14. It is also reiterated that the petitioner number 1 is suffering from cancer and a breathing space is at least required for the petitioners. Next para. Heard learned counsel for the parties. It is evident that the order under section 14 in the instant case was passed on March 11, 2022. Even going by the ratio of the judgments cited by the petitioner, the purpose of the statute is to expedite recovery and possession, comma, which is a corollary of such recovery. Full stop, next para. The ratio laid down by the division bench judgment of the Bombay High Court does not favor the borrower, semicolon, rather, comma, it indicates that the SABYASACHI action should be concluded as expeditiously as possible. Full stop. The Supreme Court observations are in similar context. Full stop, next para. Insofar as the letter dated August 2, 2023 is concerned, comma, the bank only indicated that it would take further action under the SABYASACHI Act. Full stop. However, comma, by no stretch of imagination can such communication be deemed to be a waiver of the previous order already passed under Section 14 of the said Act. Full stop. Keeping such matters in view, comma, there is no scope for the petitioners to resist the order under Section 14 of the SABYASACHI Act passed against the petitioners. Full stop. However, comma, keeping in view the physical condition of the petitioner number 1 and his serious ailment, comma, some breathing space ought to be given to the petitioners to vacate the premises. Full stop. Accordingly, comma, you'll have to file an undertaking.
Not to vacate, my lord. I would like to pay. I'm willing to pay. That's
Payment
all.
it's not 51 lakh.
No, no.
Payment
Whatever
is
the
what
due
is
is, due, I'm willing to pay the
No,
dues.
No.
No,
no.
they have sought for the dues. I'm willing to pay the dues,
Let
my
him
lord.
pay then.
Yes, I'm willing to pay. That's why I'm paying for 2 months or 1 month
No.
time.
Crore.
No further chance of
No,
payment.
no, I'm willing to pay the dues.
Next para. However, comma, while the order was to vacate the premises, leave order.
Yes.
Full stop. Next para. However, comma, when the order is being passed, comma, learned counsel for the petitioner points out that there is some misunderstanding on the part of the court insofar as the petitioners do not seek to vacate the premises but to repay the amount due to the bank.
Yes.
Full stop. Next para. However, comma, further chance cannot be given to the petitioners on such count, comma, since ample opportunities have been given to the petitioners, full stop, even after the bank having taken recourse to Section 13 within bracket 2 and thereafter 13 within bracket 4 of the SABYASACHI Act and ultimately having obtained an order as long back as on March 11, 2022, comma, the petitioners have not yet been able to repay the loan amount along with interest to the petitioners. Full stop. Rather, comma, the conduct of the petitioners betrays the intention of the petitioners. Full stop. Despite the bank having agreed once to the one-time settlement offered by the bank by the petitioner, comma, they failed to service the same, for which the bank had to adopt the methodology of seeking to implement the order under Section 14. Full stop.
I have paid
Hence,
29
comma,
lakhs.
in such circumstances, comma, no further time can be granted to the petitioners. Full stop. Accordingly, WPA 26786 of 2023 is dismissed on contest without, however, any orders to
My lord,
court.
I have paid 29 lakhs already.
Whatever.
Well, let that be recorded at least,
No.
my lord. I have paid 29 lakhs, my lord.
Next.
Grateful to your lordship. Extremely grateful. Item 6.
Yes. Petitioner, what is the matter?
But I am for the respondents.
Right.
From the took loan from the Nationalized Bank, Union Bank of India
Yes.
in the year 2016. Thereafter, petitioner time to time we repay the loan, and sometime in the COVID situation like that, petitioner typically could not reply. That is why some dues is payable. But what happened, once in a month, once the petitioner vehicle is operating on the road in question, then the muscleman, the agent, lordship, kindly see the seizure list page. I am not troubling your lordship. Page 37. This is the repossessed vehicle. No seizure list was given. Page 37. Who is given? The Calcutta investigation detective. I do not know, my lord. Who is it? 27 September 2023. No signature by the authority of.
So you are challenging this seizure?
Seizure along with even a sale notice. Lordship, kindly see the peculiar thing. They have, without following SABYASACHI Act, like this. Thereafter, my learned advocate wrote a letter. Thereafter, this is the impugned letter, Lordship, kindly see page 42. Subject notice of 15 days of sale secured movable seizure. It is beyond the scope of Securitization Act, the rule 4, specific says 30 days. Then, my lord, notice to public is hereby given, collect, distribute, and said bank holding e-auction as is what is basic condition with the instruction securitization. As borrower failed clear due secured clear, the bank has issued seizure notice dated as this is wrong. I have stated in my paragraph, my lord, they have wrong. There is no seizure notice was there. Thus, ever, sir, and taken the position of being secured as it 27 September 23. Now will be told holding public e-auction on 27 to 12 2020 at 11 a.m. How can it be, my lord? Without following the SABYASACHI Act or rules. No panchnama, nothing like that. They are following.
But they need not resort to police authorities for seizure of the vehicle. That is not the law. They can seize the vehicle under the law.
Under the law, they have to follow this.
What procedure has not been followed? This is the seizure list has been given to you.
Seizure list, 13.2, 13.4, nothing. Inventory.
Why didn't you go to the Section 17 forum, to the recovery tribunal?
Well, what happened? Well, in the meantime, we are also made the branch manager. Branch manager made a settlement, but they are not asking me how much you are paying, how much is
So your remedy lay before the debt recovery tribunal. If you had really a case, you could have gone there and obtained an interim order. The fact that you did not go there means that you actually took the loan and could not repay.
We are received only that 14th.
What for?
Kindly give some protection, Lordship.
Why should the RIT could interfere at all?
They have failed to.
You have taken a loan, you have failed to
No.
failed to repay.
No, admitted, they have.
That's not a crime otherwise, but they are entitled to recover under the law. Law is such. We cannot change the law.
4,80,000 rupees.
Whatever may be the quantum.
I am not going to ask you. They have to follow.
I'll ask you, learned friend, why the sale notice is of 15 days. That I can ask, but the recovery is all right. Inventory list is there.
Who is recovery? Not the authorized officer. Not the authorized officer. Sir.
Is there any
As
bar
per
for
the
the authorized officer?
As per the act, they have
Authorized officer might have been present. Let us hear him. Yes, what do you say?
My lord, first of all, my lord, this is not the case of the SABYASACHI. This is a car is hypothecated and my lord, the payment was not made. My lord, 2018 accounts become NPA 2018.
But can you seize like this without any authorized officer, without anything?
No.
What is this?
My lord, it is not a SABYASACHI action. So the question of authorized officer does not arise at all. This is not a case of
Muscleman can seize the car. Then you have to initiate
not
an action.
not muscleman. We have appointed an agent.
They might not have proper muscles, but they're musclemen all the same.
My lord, kindly see a person, my lord, who has taken loan.
Investigation and detective.
Yes.
Not even agency.
My lord, this
should be scrapped for the English.
Well, that is absolutely, my lord, I am not on that. But my lord, the account has become NPA 2018.
Maybe this
now,
is not
as
the way.
as of now, my lord, 9 lakhs is remaining due. 2018, my lord, the accounts become NPA and several letters was given. Several letters requesting make payment. Kindly see, my lord, the September possession was taken and sale notice has been put on 27 December. My lord, sale will be held 27 December. Ample time was given also. But they did not pay any amount. My lord, I can show the statement of accounts. My lord, this is a public money. He is plying, and what is the reason? My lord, kindly see paragraph 5 and 6. What are the reasons? Road is bad, so and so. So, my lord, the vehicles could not be run properly. My lord, these are the cases.
What about the violation of Rule 4? Security interest enforcement rules.
Well, this is not within the security. I am submitting. This is not within the SABYASACHI Act.
Say that it is not within.
It is not SABYASACHI Act. It is car is hypothecated.
If it is not SABYASACHI Act, then you have to approach in due course of law. I mean, you have to file a suit for recovery.
No, my lord, the hypothecation, my lord, since the payment was not made. And
I appreciate hypothecation, you remain the owner.
Yes.
They are not the owners.
That is the reason for which I took the possession.
But this is not a way to take possession.
I took possession and, my lord, I put up this, my lord, the property for sale.
Did you give any prior notice before possession? Where is the notice?
My lord, they have not.
No notice.
My lord, yesterday 5 p.m. this application was served. My lord, your lordships, kindly keep this tomorrow. I shall come with all other, my lord, the letters. My lord, I have got the letters, but all other letters, my lord, I shall.
Have you got the letters regarding prior notice
yes,
possession?
Yes. My lord, kindly see the
But if
notice.
the sale goes through, then everything will be over. December 11th, 2020. When is the sale scheduled?
My lord, nothing has been disclosed. Nothing has been disclosed.
27 December
27th. No, your later discloses.
Yes.
It will come back tomorrow, 10:30.
Yes.
Learned counsel for the petitioner submits that the bank has taken possession of the petitioner's vehicle illegally through musclemen and have given a mere 15 days notice of auction sale of the vehicle, without adhering to Rule 4 of the Security Interest within bracket enforcement bracket close rules, 2002.
4 and 6 also. Lordship.
Acha, 4, 5 and 6.
My.
Rules 4, 5 and 6 of such and such. Push up next para, learned counsel for the bank opposes the contentions of the petitioner. Push up the bank submits that this is not a case under the Surface Act. Push up the vehicle was hypothecated. Push up next para, subsequently the petitioner having got ample opportunity, failed to repay the amount for which the vehicle was seized upon grant of inventory list. Push up, it is submitted that as such, no contravention of any law can be made out by the petitioner. Push up, on query of court, learned counsel for the bank submits that he had got notice of the present matter being listed today only last evening and could not bring the necessary documents. Push up, it is, however, submitted on instruction that prior notice was given before the possession of the vehicle to the petitioner. Push up, in order to enable learned counsel for the bank to produce such documents, on his prayer, the matter is adjourned for the day and shall next be placed at the top of the list tomorrow.
And I'll kindly record that the account has become NPA on 30th June 2018.
I'll record that tomorrow when I take up I'll decide the matter
That
tomorrow.
is not in the letter.
I'm deeply impressed.
Yeah.
Upgraded matter, item 7.
Yes.
I am appealing for the petition.
What is the matter?
That matter, my lord, for widening the metal road by both the sides, the bank to submit report today.
Report by the district magistrate Hooghly. The matter is this, my lord, they have alleged the petitioner's lands have been, earth has been excavated by the PWD.
Yes.
During work, my lord. I'm submitting my report.
What does it say, Mr.?
My lord, some of the lands have been, my lord, excavated. And most of the, my lord, have not been culverted. And some of the lands, my lord, which lands have been, my lord, the earth has been excavated.
In last
Filled up partially and not totally, my lord. The petition, the respondent authority is, my lord.
So this is a high-handed action, Mr. Bandhavat. You cannot.
It is, my lord. Well, it has been given to the agency. Agency, my lord, excavated the land.
I appreciate
Now,
that
my
that
lord,
happens.
And they are, my lord, trying to, my lord, the compensate or by filling the earth, and it is, my lord, going on. Process is going on.
So
But
I'll keep the petition pending then. I'll seek a further report from. Thank you, Mr. Bandhavat, for the fairness. A report is filed today by learned counsel for the respondent of 4 Stroke District Magistrate, Push-up. It transpires from the report that the petitioner's apprehensions are justified inasmuch as the
one submission, my lord.
Yes.
Respondent number, petitioner number 8, my lord, said his land has not been excavated.
Acha.
And my lord,
in last
so the other petitioners' lands have been
in paragraph 5 of the last report, they are
was not absent, and such his land, my lord, could not be ascertained. Otherwise, my house all are completed.
You have to ascertain properly.
Only there in paragraph 5 of the last report, that is they are in problem. Whether there is any land acquisition proceeding has been done or not.
Nothing has been done.
No.
Nothing has been done. If it was done, they would not have considered.
Without any notice, nothing of the sort. I have to look into the if the exception is there, I have to file on the next. If
inasmuch as the lands of the petitioners, apart from petitioner number 8 and 10, have been admittedly excavated by the respondent authorities, Push-up, insofar as petitioner number 10 is concerned, he was not present, and as such, it could not be ascertained at the time of inspection as to whether there has been any excavation on his land. Full stop, next para, thus, comma, a prima facie strong case has been made out by the petitioner that the respondents have undertaken, comma, by high-handed action, comma, the work of excavating the petitioner's land without acquiring the same or without prior notice to the petitioners, comma, which
Formal
is
matter,
deplorable. Full stop, next para. Accordingly, comma, it is for the respondents to restore the properties wrongfully excavated to their original position. Full stop. The question of whether the petitioner is entitled to compensation for such harassment is kept open for being decided at the time of final hearing of the writ petition. Full stop. Next para. However, comma, the restoration work shall be done with immediate effect, and a further report shall be filed by the respondent authorities on the next returnable date, comma, with an advance copy to the learned advocate for the petitioner, indicating that such restoration work has been completed and the properties in questions which were wrongfully taken by the respondent authorities have been restored to the respective petitioners. Full stop. For such purpose, comma, the matter be listed on 1 month will be reasonable, Mr. Bandyopadhyay.
time.
I'll keep it after 1 month. Let us see. The matter shall be listed on January 22, 2024 at the top of the list for passing further orders and for filing of further report by the respondent authorities.
And since I have not gone through the in respect of 8, I could not.
Next para, it is made clear that while doing so, comma, the petitioner, the respondents shall give a further notice to to petitioner numbers 8 and 10 and have a further inspection to explore whether the
Petitioner number admitted, he was present, that his land has not been excavated.
I just have got it. And
anyway, to petition numbers 8 and 10 to explore whether any portion of their lands have actually been excavated. Full stop. The report to be filed on the next returnable date shall also incorporate a section regarding the outcome of such exploration regarding petitioner number 8 and 10. Thank you. Give them another opportunity, Mr. Bandyopadhyay. Ask your officers to give them another opportunity. 10 will be given another opportunity and 8 also. If he can produce something, otherwise you give it to me.
Almost all the days they are going, and yesterday also they came to the petitioners. Cordial relation is there for in respect of carrying
Item
out my
8.
lordship's order.
Yes. 8 is for the petition.
Grateful man.
Yes, Mr. Das, what is that?
This is regarding that.
Malad, file ABDP composition, Malad. As per direction, Malad.
Friend, Malad, the matter has been resolved. Malad, it is regarding engrossment of a settlement deed.
If it is resolved, I'll just dispose it.
Now, they have taken the pain to contact the police authorities and sought a copy of the impugned settlement deed. And that they have come to a finding that it is the one that I am looking for.
Very
now, Malad, we pray for a solemn order from my lord.
You will pay the amount and to get back the.
Yes, let there be direction upon the police authorities who have seized the document to make over the original document to the registering authorities. Subsequent to that, they will adjudicate and find out the stamp value to be paid. That I will pay and my deed will be regularized.
Can you adjudicate? Can you assess the stamp on the photocopy? Because that is a subject matter of investigation before the police.
My lord, stamp duty already been document was 1991. At that time, no, my lord. Photocopy, that is the only for adjudication as per direction, my lord. Then start the copy of this ADSR and ADSR.
He presented the deed for registration long back. After
that original deed, my lord,
yes,
seized by the police authority.
Police authorities, because the stamp paper was forged.
Yes.
That is the investigation.
Yes. Among that, police authority has directed, my lord, the original deed sent to the ADSR respondent number 3 for adjudication of this stamp duty.
Oh, that has been sent?
No.
You are asking for a direction.
Thereafter, adjudication, my lord, the stamp duty, the petitioner paid the amount and obtained the deed.
But you will have to return then the deed to the. But you will have to produce that again to the for the investigation.
That is the problem.
The investigation will then be hampered.
A certified copy may be.
Certificate copy to you then.
Yes, certified copy to me. Let the original go back to the police authorities, and I will. It will be good for me. Certified copy will be good enough for me.
No objection, my lord.
Affidavit in opposition filed today by respondent number 3 be kept on record. Full stop. Learned counsel for the petitioner submits that in view of the stand taken by the respondent number 3 in the affidavit in opposition, comma, no reply is intended to be filed. Full stop. It transpires from the pleadings of the parties that upon ascertainment, comma, the respondent number 3 is now of the opinion that the deed in question indeed tallies with that of the petitioner, comma, which was presented by the petitioner for registration. However, comma, subsequently, due to the ongoing police investigation regarding alleged forgery of the stamp papers put on the deed, comma, the original is lying with the police authorities. Next para, it is submitted that if the document is returned to the registering authorities for the limited purpose of assessment of stamp duty, comma, the petitioner shall put in the said stamp duty and will be satisfied with a certified copy of the same. Full stop. But that will be difficult. If the stamp duty is replaced, then what will remain in the investigation? Then the fresh stamp duty, you have to put in the money equivalent. All right, you will accept the money equivalent from them as the stamp duty.
Yes, yes.
I'll put that in my order.
Yes.
The next para. In such peculiar scenario, comma, the following order is being passed. Colon. Next para. The police are not a party here.
No.
Then how can I direct?
That is my problem, man.
What parties? Let me see. State is a party.
State is a party.
Upon the investigating authority, comma, which is in charge of the investigation regarding the forged stamp papers on the deed of the petitioner, being approached by the petitioner with a server copy of this order, comma, the investigating agency shall act upon the same and shall hand over the deed containing the allegedly forged stamp papers under a special seal and cover to the respondent number 3, that is the additional district sub-registrar, Potashpur. Next para. Such handing over shall be done within a week from the date of being approached by the petitioner. Upon the same being handed over, comma, the respondent number 3 shall intimate the petitioner a particular date on which the petitioner shall be present and deposit the money equivalent of the stamp, comma, which is alleged to be forged. Upon receipt of such amount, comma, the same will be treated to be sufficient equivalent of the stamp payable by the petitioner for registration of the deed. Accordingly, the respondent number 3 shall complete the registration of the deed. Thereafter, comma, a copy thereof shall be retained with the office of the registrar. The immediately after such process is over, comma, which is expected to be concluded within a month from the handing over of the document by the investigating agency to the respondent number 3, comma, the registered deed shall be returned to the police officers, comma, along with the allegedly forged stamp papers, comma, for conclusion of the investigation. In the event the petitioner applies for a certified copy of the registered deed, comma, the same will be furnished by the registering authorities in due process of law, subject to the petitioner complying with due formalities for getting such certified copy. Thereafter, next para, it is made clear that nothing in this order shall influence the ongoing investigation regarding the forged stamp papers in any manner whatsoever. The above order has been passed only to facilitate the completion of the registration of the deed, comma, due to the inconvenience being suffered unnecessarily by the petitioner on such count. WPA 9709 of 2021 is accordingly disposed of in the light of the above observations.
My lord, one submission, my lord. Yes. Seriously, one 83 seized deed, my lord. Particularly mentioned regarding the
That particular deed number may be mentioned.
যেখানটা বলেছি shall return the deed with the following observations বলে particular deed give the deed number to my office.
দিয়ে দাও deed number.
Being deed number such as.
Yes.
Thank you. You are correct. Next.
Item 9.
9, I appear for the petitioner.
Yes, what is that?
The challenge is to disposal of Section 18 application by the Central Information Commission.
Pending.
Disposed of 18 on the erroneous assumption of facts. Lordship sees page 30. That is the order passed by the Central Information Commission.
30.
30. It starts earlier. 30.
Yes.
The last paragraph.
Right.
The complainant stated that he is aggrieved with the fact that the information provided by such and such is based on false submissions of ICBI Bank.
Right to information act. Yes.
He further insisted that the CPIO, being also the dealing officer of the vigilance complaint filed against him, was required to ensure that corrective action was being taken by the IDBI Bank. This is a absolute erroneous finding because the complainant here, the petitioner here,
Yes.
was the complainant. He made a vigilance complaint. He was not being investigated. On the basis of his complaint, IDBI Bank was being investigated or inquired upon by the vigilance.
Yes.
This is an erroneous fact finding, erroneous recording of submission, on the basis of which the commission proceeded. And kindly see the next paragraph. He furthermore urged that the inaction/action of IDBI Bank in approving a malafide departmental inquiry against him 5 days before his retirement has caused him tremendous detriment. This is also wrong. There was no departmental inquiry against this petitioner ever. What was urged?
Furthermore, this he is you.
This he is me.
This was a wrong recording then.
Wrong recording.
Then you had to approach before that forum. If
I had.
What happened after that?
Nothing.
So you were only against this recording.
This recording.
What was the decision taken?
The decision was dropped because they found that I was harassing the CPIO because of my personal grievances, because they took it that as because I was investigated by this person, I have some personal vengeance to prove against this person.
What was the ultimate decision? Drop.
Kindly see page 31, drop. Page 31, the decision sees, kindly see, decision totally deals with my allegations against the CPIO on a wrong finding of facts. As if just because I was complained against, I have my personal grievance against the person. Ultimately dropped, and I had brought this to the notice of the commission by writing a mail. Kindly see page 34 onwards.
Which respondent should be?
Of the State Central Information Commission.
Show me something to show that you are the complainant and something of that sort. That you are the complainant. These are wrong.
Kindly see page 34. I have ever specifically brought this to the notice after this order was informed to me. Page 34. Strange miscomprehension that prevailed over the whole process. She repeatedly making the fault coming orders. What should I do? And kindly sees the second paragraph in page 35. It appeared that she still could not get to the truth of the matter, as she was under the impression that CPIO was the dealing officer for a vigilance complaint against me. Kindly note that there is no vigilance complaints against me. Rather, Jane Chopra was the dealing officer for a vigilance complaint made by me against the IDBI.
Let us see the decision portion of this order. Please read that also. The commission observes from there, page 31.
The commission observes from a perusal of the facts on record as well as from the contentions of the complainant that the instant complaint is not about the violation of the provisions of the RTI Act, but regarding the administrative decisions of CBC and IDBI Bank in relation to the avowed vigilance inquiry said to have been initiated against the complainant. So on the erroneous finding of facts, the decision is being taken. Pertinently so, the complainant has not even sought for any information. This is also wrong. In the instant RTI application, as he has merely narrated factual statements, in this context of his application, as he has merely narrated factual statements.
Where is your information? What did you?
First application is page 15.
This was the first authority.
The first authority, CPIO. Page 15. Kindly sees the online one, the third paragraph. The entire narration is perhaps important. Kindly go through.
What is the information sought?
Well, the information sought was a document with regard to the action taken by the Vigilance Commission pursuant to my complaint. What they did was they cited two memos that by virtue of such and such memo, the matter has been ordered to be taken up by the MD of the bank, that this is the finding of the commission. I wanted a copy of that memo.
No, but she is correct, because whatever you have said here is these are rantings against the vigilance.
Well,
I mean, there
kindly
is no
see-
information specifically sought at
Yes,
this.
well, I have
What
kindly
is that?
see the
Give the
second last paragraph from the bottom. It is learned CBC had issued another direction in September 2019, which has not been duly complied with till date. I also need a copy of the CBC memorandum number such and such by date such and such, wherein it was advised that the reference has been examined by the commission and directed the bank that the matter may be placed before the MD CEO for
These are in the nature of allegations. She is correct.
But
You say it is learned that CBC had issued another direction
Yes, I-
when, which has not been duly complied with till date. I also need a copy of the CBC memorandum wherein it was advised that the reference has been examined by the commission and directed the bank that the matter be placed such and such. No proper resolution has been offered till date. Also, I doubt whether the matter has been placed before MD. These are all allegations. File a proper application, pinpoint the information you seek, and that will be decided. This is not an information application.
kindly bear with me. Well, I had specifically
You
sought
cannot
for
couch it like this.
this has been written by
No,
the
no,
person
this is
concerned.
not the business of the information officer to go into this. She is absolutely correct.
Well, with regard to this, well, why am kindly
Entirely allegations, your rantings against the vigilance.
Well,
You
not-
may have your forum for that. Do that. But
Well,
before an appropriate
Well,
forum.
may I place the factual narration once? What happened? Man?
No, we have to look only into your information application.
Yes, well, this is on the
Actual
basis
narration cannot be gone into.
No, I'm not against because
We
RTI
have to
is
look
only-
into your RTI request. This is not a request at
Well, I
all.
have
This is a
sought for
complaint.
Well, I have sought for a document which is specifically that I need a copy-
Specifically, stipulate, indicate the document. Get your document, I'll give that leave.
Well,
But
kind-
she is right on this.
Well, I need
I'll
a-
say this will not preclude you from filing a proper application and seeking the exact document or information you want. This
Well,
is not such an
well,
application.
kindly bears with me. Well, why it's to the stage of complaint? This is the first
Yes.
section 6 application. Well, I sought for information with regard to the CBC memorandum specific.
No, this is not specific from them.
Well,
You have not
I
sought-
also need a CBC copy.
You may need it, but you are not asking for it from them. You are very vague. It is learned that CBC had issued such and such wherein it was advised. I also need a copy. You may need it.
Well,
You
because-
have to just apply, say I need this document, say that and get your copy.
Well,
But the previous paragraphs, subsequent paragraphs,
that deals with the earlier or
No.
grievances. But well, what happened here is
cannot ventilate those grievances before this officer in that capacity.
Well,
He is
ki-
absolutely right.
well, kindly yes, my lord. This memorandum was required by this person to take up the matter with the bank. That is not out within the ambit of RTI Act. Well, I know. Well, Lord, what happens is this information was not supplied to this person. So he made an application.
You may have your grievances. We are not on that. All these grievances may be very correct. But even for that, you have different forum for that.
Well, that is pending. That is
Let
pending.
that be
is
pending.
separate
But
subject
this
matter.
cannot be subject
I
matter of
wanted
information.
this document because this document is very important to me. Because by virtue of this, as per my complaint, the CBC had
You only have to fill up a column, say this is the information wanted. You say this is the document I want. That much.
he has complicated the issue. Well, I understand. He has made rantings. He has made
Yes,
comments which-
conceal the real thing between so many, shrubs that it cannot be deciphered even.
That was the problem. Well, but what
Very
happens
give you
there-
liberty to file a proper
Well,
application on this.
What happens there?
What happens?
Well, in reply
After
to-
this, something happened also.
Yes. Well, after that they reply. The reply is at page 17. Well, annex P2.
No, ultimately, we are sitting over judgment on the Section 18 application.
My lord, I want
Section 18.
Section 18
It
because
has reached up to the Section 18 stage.
my lord, because the information provided pursuant to this was something else.
Let us see that
My lord.
information. Page 18.
Page 18 is a letter written to me, addressed to me by the CPIO, referring to a letter issued by the bank to the CBC. I had never sought for this. I specifically asked for what the CBC did.
Where is your complaint under Section 18?
Section 18 complaint is at page, my lord, 27.
While in service, have suffered huge career loss, huge loss of salaries.
With regard to
For a minute, don't think that for a minute I am not sympathizing with you if you have really have a case. Undoubtedly, you may have suffered a lot, for which there are other remedies in law. Definitely explore those to the fullest. This is not the job of the Information Commissioner.
I need that document. Unless I get hold of that document, I cannot place it
What
before any other.
document?
That CBC memorandum.
Page 27, show me what document you have referred to.
CBC
Even
memorandum that I have specifically.
no,
Not 27. 27 is the complaint. I made the complaint because that was denied and that
even in the
page
complaint here, have you indicated this document was sought, this was not given, something else was given? Nothing of that sort. More stories.
Right. The personal grievances.
The present challenge has been you are appearing. No, not in this way. Despite service, none appears for the respondents. The present challenge has been preferred against an order passed by the respondent appellate authority in connection with a complaint lodged by the petitioner under Section 18 of the Right to Information Act. The petitioner complains that the petitioner sought for specific documents in connection with a vigilance proceeding. Such, however, the first authority gave some information which is totally irrelevant to the issue. As such, the petitioner lodged the present complaint, which has been turned down by the respondent number 3.
Respondent number 3. 3, my lord.
By the respondent number 3 on grounds which are alien to the original information sought by the petitioner. Next para. A perusal of the online RTI request annexed at page 15 shows that the same comprises more of rantings, RANTINGs, and allegations on the count of the vigilance proceeding and less of information sought by the petitioner. Next para. Embedded somewhere inside such allegations is a statement that the petitioner needs a copy of a CVC memorandum number 1733 BNK 21 dated September 16, 2019. Next para. Thus, there was sufficient scope of confusion in the application for information made by the petitioner in the first place before the first authority. Next para. Subsequently, when the matter went up before the respondent number 3, the petitioner in his complaint under section 18, annexed at page 27 of the writ petition was all the more vague and ventilated his grievances otherwise regarding the vigilance. Regarding the vigilance proceedings. Although the petitioner may very well have a good case regarding inaction on the part of the appropriate authorities in connection with the vigilance proceeding initiated on the petitioner's complaint, the same cannot be the subject matter of an RTI application or an application under Section 18 of the RTI Act emanating therefrom. Next para. Thus, I do not find any illegality on principle in the order of the respondent number 3, which observed that the allegations of the petitioner had to be ventilated elsewhere. Next para. Be that as it may, the petitioner, indeed, has the right to seek the information document by making a specific pinpointed application specifying the exact information and or document sought by the petitioner under the appropriate format envisaged in the RTI Act. Next para. Hence, WPA 10196 of 2021 is disposed of without interfering with the impugned order, but granting liberty to the petitioner to make a proper application, specifically indicating the exact information document sought by the petitioner without filling up the said application with unnecessary extraneous allegations. Next para. As and when such application is filed, the first authority shall deal with the same in due process of law in accordance with the provisions of the RTI Act and give a response thereto. Next para. Nothing in this order or the orders impugned herein shall be an impediment to the respondent authorities from giving proper information document to the petitioner as sought for under the RTI Act, if the petitioner is otherwise so entitled in law. No orders to cause urgency.
With regard to the recording of erroneous that I was vigilance, they inquired against me, that part, because it remains.
আচ্ছা আরেকটা লাইন আচ্ছা WP disposed of এর আগে accordingly disposed of এর তার আগের লাইনে ঢুকবে the petitioner has also alleged that the facts were inverted while narrating the impugned order by the respondent number 3 authority, comma, inasmuch as the authorities proceeded on the premise that the allegations in the complaint were made against the petitioner, comma, whereas the petitioner was actually the complainant. Next para. However, comma, such findings shall not be binding on the parties in any future matter and have to be deemed as tentative only for the purpose of the adjudication by the respondent number 3.
Any time frame, my lord? Time frame of reply, if I, because it takes years otherwise.
যেখানে শেষ করছি no address to cost এর আগে the if such an application in appropriate format is filed by the petitioner within a fortnight from date, comma, the first authority shall dispose of the same as expeditiously as possible, comma, positively within 1 month thereafter.
Grateful. I apologize for troubling your lordship.
And you have to be troubled. Yes.
Item 10.
Yes, 10 who is a your applicant, yes.
My lord, what?
You want to apologize first or give the trouble first?
My lord, everything first, sir.
Yes, what is the matter? Yes.
My lord, one gentleman, he's a rich man. My lord, he is the owner of certain land.
One gentleman is a
Rich man.
rich man.
Yes, the private respondent. My lord,
My landlord is also a rich person.
No, no,
That's why he's represented by Mr.
He's the rich man over here.
Now, he purchased the land constructively, and we are the man. We are
The respondent is the rich man.
yes, yes. Bidding
Not
party. And my lord, we are the hawkers, physically handicapped. We are running for it. Now, all on a sudden, the order.
All the petitioners are physically handicapped.
Yes.
Acha, acha.
The documents have been given.
No, you come under a particular scheme or something.
No, no, no.
All of you are handicapped.
Handicap.
Acha,
Handicap. This is the my lord position. They are the one.
Get the photograph with you. My court officer may be interested. Give it to him.
No, one is smoking, my lord. That's why I am feeling shy.
Smoking?
That is bad for you.
No.
Mr. Sabud was smoking there.
No.
So what happened after the smoking was over?
Now, my lord, order was passed by the Honorable Court to consider. Now, DM has passed it.
Pardon?
What was he smoking?
No, what is the grievance about?
Grievance, my lord, there was direction for our removal. We approached the district magistrate. Since then, my lord, matter is pending. Out of sympathy, we have not been disturbed. Now, my lord, after when the matter is recently, my lord, a notice has been issued, my lord, by the engineer, assistant engineer. I have kindly it did, my lord, take to. Now they are saying that this is also a vague.
Ms. Banerjee, you don't have a seat behind you. Take your seat.
Removal of encroachment from PWD roadside government land in plot number.
Yes.
এটা একটা নতুন দিয়েছে ওরা মৌজা ইসলামপুর ডিস্ট্রিক্ট মুর্শিদাবাদ as per order such and such.
So they'll have to take appropriate proceedings under the law.
Yes.
This is the prelude
In
to that.
connection with the above subject, you are requested to remove the unauthorized encroachment within December 18 from the above mentioned government land as demarcated by BLR, failing which encroachment has been removed. In any,
I'll delete the D's.
So now, my lord, now I have been told that after when the matter is appearing, your lordship.
So what have you challenged in the first place?
Challenge, my lord, order of removal. Then we have made a representation. Kindly look at page 34 to the district magistrate. That we আপনার আমাদের বিনীতি নিবেদনে যে আমরা উল্লেখিত সাকিমের স্থায়ী বাসিন্দা হইতেছি আমরা ইসলামপুর বাস স্ট্যান্ড সংলগ্ন রাস্তার ধারে অন্যান্য লোকজনের
What is the actual document which is under challenge?
হ্যাঁ that is the order of removal. Yes. Thereafter, my lord, as per provision, we approach the district magistrate. টেবিল ইসলামপুর বা সংলগ্ন রাস্তা অন্যান্য লোকজনের মতন টেবিল পাতিয়ে কেউ চায়ের কেউ মিষ্টি কেউ লটারি বিক্রি করে দিনাতিপাত করতেছি হঠাৎ জানতে পারি যে 1 নম্বর শাসানসাজ 2 নম্বর শাসানসাজ মহামান্য হাইকোর্টে একটা উচ্ছেদের মোকদ্দমা দায়ের করিয়েছেন একতরফা অর্ডার পাস করিয়ে লইয়াছে উপরিউক্ত আমাদেরকে কোনরূপ
চিঠি না করিয়ে কোনরূপ হিয়ারিং এর সুযোগ না দিয়ে একতরফা অর্ডার পাস করিয়ে লইয়াছে। আমরা উপরিক্ত মোকদ্দমায় কোনোদিনই পার্টি ছিলাম না। আপনি আমাদেরকে উপরিক্ত বিষয়ে চিঠি করলে আমাদের পক্ষে উকিলবাবু আপনার নিকট আমাদের কাগজপত্র জমা দেন ও হিয়ারিং করেন। আপনাদের শুনানিতে পরবর্তী দিন ধার্য করেন ইংরেজি 5/7/18 তারিখ। উক্ত তারিখ উকিলবাবুদের ধর্মঘট থাকায় ও আমরা অজ্ঞমূর্খ ব্যক্তি হয় উক্ত তারিখে হিয়ারিং উপস্থিত হতে পারি নাই। সেই সুযোগে উপরিক্ত লিখিত ব্যক্তিরা আপনাকে ভুল বুঝাইয়া উকিলবাবুর অনুপস্থিত সুযোগ লইয়া গত 7/5/18 তারিখে একতরফা অর্ডার হাসিল করিয়া লইয়াছে। সেই কারণে গত 7/5 তারিখের একতরফা অর্ডারটি রদ ও রহিত আমাদেরকে পুনরায় হিয়ারিং সুযোগ একান্ত আবশ্যক, নচেত আমাদের অপূরণীয় ক্ষতি হবে। আমরা উপরিউক্ত ব্যক্তিগণের চলাচলের পথে কোনোদিনই অবরুদ্ধ করি নাই, বরং উক্ত ব্যক্তিগণ ইসলামপুর বাস স্ট্যান্ডের ব্যবহৃত নয়নজলিটি
The
যে
difficulties you have lost up to an appeal before the district magistrate.
now my lord, after
What remains now?
Monday I mentioned it, Tuesday it appeared. Now I have been informed, but told that the authority out of sympathy they have said no, no.
How can they settle anything?
No, that we should not be removed. We have
The order has been affirmed up to the appellate authority.
Yes.
Now, what can the district court do? I mean,
So, my lord, as the matter has been settled,
what?
my lord,
So you are not pressing the writ petition?
yes, man, kindly do that because these are the table people. They are doing now. They have the local engineer, the officer in charge, block down. They are.
He has been managed.
I have no.
He's also smoking probably there.
My lord, no, because smoking a bidi.
বিড়ি খাচ্ছে?
তো কি খাবে? সিগারেট পাবে কোথায়?
The BD may taste better than cigarette. BD flavor is much better than cigarette. Anyway, let us not discuss BD and cigarette now. Now, if you then you are not willing to proceed, should I record that? I'm not putting any.
Yes,
Should
my lord.
say that only.
In view of recent development, I am not proceeding.
Very well. Learned counsel for the petitioner submits that the writ petition had been preferred against an endeavor by the respondent authorities to remove the petitioners by labeling them as encroachers. Footstep, next para. However, comma, during pendency of the writ petition, certain developments have occurred due to which there has been a settlement out of court. Footstep. As such, comma, learned counsel for the petitioner submits that the petitioners do not want to proceed further with the writ petition. Accordingly, WPA 15081 of 2021 is disposed of as infructuous on the basis of the submission made by learned counsel for the petitioners.
And
No address to cause urgent said.
Subsequent developments.
That I've recorded.
I am grateful. As soon as matter appeared, my lord, these things happen.
11.
Yes, 11 who is appealing.
I am grateful.
Service has been effected?
Yes.
Yes. What is the matter?
Lord, matter is this, my lord. Lord, the mother of the petitioner was the state government employee.
Right.
Lord, she was attached to Department of Health. She was attached to BC Roy Memorial Hospital, GDA. Lord, she retired in the year 2007. Thereafter, my lord, she expired in the year 2013. Lord, in the meantime, Lord, the state government introduced a scheme, West Bengal Health Scheme. Lord, she became the member of the health scheme. Lord, card was issued. Lord, benefit is this.
That is the Shastro Sati scheme.
No.
Something else.
Difference.
Acha.
Lord, if any treatment is made and the bill is presented, then the amount would be reimbursed.
Right.
Lord, during the lifetime, the bills were submitted by the employee, retired employee. Thereafter, my lord, no payment was made. She made representations. That was not adhered to. Thereafter, after the death, his one of the son was entrusted by the other heirs to claim the amount. He also claimed. No reply. Thereafter, he raised the grievance in the public address grievance cell. Thereafter, it was intimated that your grievance is pending for further
action
assessment. No reply till date. That is the grievance.
I'll direct them to do it within a month. They not a month, less than that. I'll direct them to assess the amounts payable to you and disburse the amount.
My.
The grievance of the petitioner is that the petitioner's mother, who was an employee in the BC Roy Hospital, which is a government hospital, retired in the year 2007 and subsequently expired in 2013. She had she had enrolled under the West Bengal Health Scheme during her lifetime, which covered the medical expenses undergone by the deceased mother of the petitioner. However, despite having presented several bills during her lifetime, the petitioner did not get any such amount. After her demise, the said claims were reiterated by the petitioner on behalf of all her heirs. However, even after several representations and assurances of steps being taken, nothing has been done to disburse the said amounts which had accrued to the petitioner's mother during her lifetime, by the respondent authorities. Despite service, none appears for the respondents to refute the claims. Affidavit of service filed to be kept on record. WPA 4035 of 2022 is accordingly disposed of by directing whom should I direct?
Respondent number 2, 3, and 5.
3 and 5.
2, 3, and 5.
Very good. Directing respondent numbers 2, 3, and 5 to ensure that the bills presented by the petitioner on behalf of his mother and the petitioner's deceased mother during her lifetime under the West Bengal Health Scheme be assessed immediately. Such assessment shall be concluded positively within 3 weeks from the date of communication of a server copy of this order to the said respondents. Immediately thereafter, the bills assessed to be due in that regard shall be disbursed to the petitioner on behalf of all the legal heirs of the deceased mother of the petitioner, within 3 weeks thereafter. Next para. It is made clear that the merits or veracity of the claims of the petitioner have not been entered into by this court, and it will be open to the authorities to assess the same independently without being influenced in any manner by any of the observations made here. No rest to consult. 3 weeks consideration, 3 weeks disbursement.
Item 12.
Yes. Yes. What is the matter?
Lord, I had filed a writ petition before this honorable court.
Yes.
In the year 2019, challenging the notice issued under SABYASACHI Act to a third party who is the private respondent on the ground that the 4 properties, my lord, shops at the Garihar.
What is your locus standi?
My locus is I am the purchaser. The deeds were mortgaged with the bank. Thereafter, at the settlement arrived at.
You are a purchaser from the borrower?
Yes. It was an arrangement whereby the bank permitted the borrower to sell the property and I paid the consideration money. However, the title deeds were not released. As a result, conveyance also could not be executed in my favor. But this was the situation when the writ petition was filed. Subsequently, my lord, we have come to learn that in the year 16 November 2022, my lord, the borrower had also challenged the notice issued under SABYASACHI Act before the Bombay Debt Recovery Tribunal, Mumbai. There, my lord, an order has been passed whereby the notice under section 13(2) has been set aside. In that order, my lord, I have annexed that order, my lord, wherein it has been categorically admitted by the bank also that these 4 properties which have been sold to me, my lord, have been sold to me, and the bank, the honorable learned DRT has also come to a finding that this section 13(2) notice includes the property already sold and has set aside the entire notice. So therefore, my lord, today I have a very innocuous prayer because there is no proceeding under SABYASACHI is pending. 13(2) notice has been set aside, therefore 13(4) also goes, my lord. I just beseech your lordship, the direction be given upon the bank to release the title deeds. This is all what I want.
You did not pay the entire consideration. Why were they
Entire
withheld?
consideration money.
Why was it withheld in the first place?
Bank had withheld it because bank had other dues with the borrower. But so far as these 4 properties are concerned, my lord, admittedly, my lord, these were sold with an arrangement with the bank. And 85 lakhs, my lord, I had paid to the bank at that point of time in 2018.
Very. Yes, what do you say?
Only incorrect submissions have been made. I tender my
It's an
apology.
incorrect submission.
Yes, I tender my apology to say, but this is the fact. First of all, Your Lordship, apart from the maintainability, I will also point out other points. Kindly see the array of the parties. Who are the parties? The authorized officer Axis Bank and the Axis Bank Limited. This is my first point. The reliefs which has been claimed both in the writ petition as well as in the CAN, Your Lordship, whether such reliefs can be granted against a private bank in a writ petition under Article 226, Your Lordship. This is the second point which is to be considered. Third point, Your Lordship, what is the locus of the petitioner? The petitioner is not the borrower of the bank. There is no arrangement, as alleged by my learned senior friend, between the bank and the petitioner herein. The petitioner has failed to show a scrap of paper that at any point of time, bank agreed to release the property in favor of the petitioner. The alleged sale which the petitioner is alleging, that per se is illegal, because while the property is lying mortgage with the bank,
That was an arrangement between the petitioner and the borrower.
yes,
Private
bank
arrangement.
has no knowledge. Bank is not concerned. Even it is admitted position that the amount, the alleged amount, was paid by the petitioner to the borrower.
Affidavits have been exchanged in this matter.
No, Your Lordship, no
What
direction.
affidavit? Put in all your documents.
Yes, Your Lordship.
How soon can you do it?
My lord, kindly, if I place before lordship two documents.
So let them put in their affidavits. Locus standi point you also have to answer me.
My lord, locus
No
standi
arrangement
point, my lord,
between at all.
I
So
shall
the
answer.
arrangement between the bank and you.
Yes, I
then-
shall show that also, my lord. In
You
fact,
have
now
something.
today,
Yes.
13-2, I have made the borrower also as a party in the writ petition. That is why.
No arrangement. You have annexed something regarding the arrangement with the
Yes,
bank.
yes, documents are there, emails exchanged between the parties are
File
there.
your opposition within first 2 weeks of January. Within 12th January, file your opposition.
Your Lordship, 2 weeks maybe after the vacation.
Yes, 2 weeks after the vacation.
2 weeks.
Learned counsel for the petitioner raises certain arguable questions. First up, it is alleged that the petitioner had purchased a property which was the subject matter of a SARFAESI proceeding, from the borrower in an arrangement to which the bank was also a party. First up, after the petitioner paid the full consideration for 4 properties which were the subject matter of the proceeding, a challenge was preferred by the borrower before the notice under section 13 within bracket 2 and consequentially the measures under section 13 within bracket 4 of the SARFAESI Act were set aside. Full stop, next para. Thus, the petitioner now seeks a return of the title, a release of the title deeds regarding such properties in favor of the petitioner.
My lord, this fact is also recorded by the learned DRT on 16 November
That is
2022.
incorrect.
Yes.
Very well. Then
What
council also
I can show.
Yes, I will.
then council also submits
Is it
that
correct?
these
I can
facts have been recorded in the relevant orders of the Bombay DRT. Push up next para. The allegations are controverted by learned counsel for the bank, who refutes the maintainability of the writ petition on several counts. First up, it is submitted that the writ petition is bad not only for non-joinder of necessary parties, but the petitioner does not have any locus standi.
My lord, my learned friend has not taken the point of non-jointer of necessary party.
Oh, you say this is a private party.
Private.
Acha, non-joiner is not only bad for being against, not only bad for being preferred against a private entity which does not come within the purview of state within Article 12 of the Constitution of India, but the allegations made on fact are incorrect. Full stop. It is argued that the bank was never a party to any arrangement between the petitioner and the borrower, and if such transaction has been undertaken, the same was at the risk of the petitioner and without the knowledge of the bank. Full stop. Since the basic premise of the petitioner's contentions are controverted, the matter is required to be heard on merits. Full stop. The respondent shall file their affidavits in opposition, taking all points therein by January 12, 2024. Full stop. Reply, if any, shall be filed by January 19, 2024. The matter be placed for hearing on January 22, 2024. Full stop. Next para. It is made clear that the objections as to maintainability are kept open for being decided at the final hearing of the writ petition.
But let my learned friend file the opposition both to my writ petition as well as the Ken's.
Right. যেখানে affidavit in opposition বললাম, affidavits in opposition both to the writ petition as well as the interlocutory application. তারপর রিপ্লাইটা যা আছে বললাম, বুঝছো? নেক্সট প্যারা, shall appear for hearing, the matter shall be listed for hearing যেখানে বললাম, the matter না করে the writ petition as well as the connected application shall be placed for hearing.
May I file my affidavit of service? And my lord, I am beseeching my learned friend that I am requesting her, let her take instruction, because I think she is not properly instructed. The recent development that
She
has
thinks the same about you. So it's mutual. Let us come back. Yes. Next. Call kar.
Item 13.
তাড়াতাড়ি কল করো, অনেকগুলো পেন্ডিং আছে। Yes, 13.
May I make a prayer, my lord?
Yes.
Which I would perhaps not have made if it was on the other side of the vacation.
Yes.
Trying to take advantage, my lord, unduly. My lord, there was an amendment application which was allowed. One prayer was inserted. Now, my lord, amended petition has been served. My lord, may I file an affidavit dealing with the prayer, only to ensure it goes over till the 2nd of January?
The affidavit regarding a prayer.
Actually not required. The final hearing matters, my lord, one day before vacation.
What is your urgency?
Lord, the urgency is this, my lord. No, this man, my lord.
He has been running from pillar to pillar every day.
No, I
He
appreciate.
has not gone to any post, but he has been running from pillar.
My lord, I appreciate, my lord, he is here. I'll do it, my lord. I'm ready.
Then let's.
But I'll just.
I don't appreciate, because if it's a long matter, you have to.
I'll take
I'll take
time. I've got at least 13 judgments. I'll take time.
No, that's
But
all
my
right.
lord, no, I'm just finding out.
Terrorism.
You will be here on the 2nd of January.
No, that's very irrelevant
Before
question,
opens
Lord.
later.
If you want to cite
So we'll
13
do it
judgments
on-
on that ground, I'll grant you an interim order. What is the interim order?
Interim order is man.
Can we do it on 2nd
No.
January?
No, it opens on 2nd.
Oh, then we'll do it today. I don't want to.
What
get
is the urgency?
No, the urgency is this, my lord, that the man, my lord, is wholly ineligible. He is the only Shia representative. He has to be a theologist. Theology is a science. You can't have a man, my lord, who does not have the
As
qualification.
what? A marriage registrar?
No, my lord. As a member of the Waqf board.
Oh.
And in fact, your lordship, my lord, by order dated 9th August, had indicated the urgency and incorporated the same in the order. Saying, my lord, that a man who does not have it, my lord, how can he continue? I think it's an order just before that.
Yes, yes.
Just before that.
They did not appear during the hearing.
So, my lord, the factual issue is very small. The factual issue is, my lord,
This is your notes of arguments.
3-page notes of argument.
Where is your
I have
notes? You
amended
likely to come prepared with the notes on the last occasion.
I have amended it a little
Lord,
bit.
I'll
my lord.
file it tomorrow, my lord. I'll argue it today, file it tomorrow.
I've
my lord.
recorded it in.
I'm sorry, my lord.
On 9th of August, the recording was parties are directed to come prepared with the written notes of arguments. File the same on the next written.
My lord, it escaped my attention.
Sali was there.
My
That's-
written notes of argument, I appear for the state.
If the
Yes,
state is
it-
prepared
it-
with the written notes of argument, just understand the state of affairs with your client.
Yes, my lord.
The
with-
state is
with
even
me-
ready with the written
With
notes of-
me, I should have, my lord, looked at the last order, my lord. My lord, permit me to argue today. I'll file my note tomorrow.
What is your point? Please indicate.
Point, my lord, is, my lord, if your lordship kindly have, my lord, the work.
My lord, I'm just one. I'm sorry to.
No, it's all right. Yes.
But before my learned friend proceeds with the matter, when this matter was initially taken up, we raised the point of maintainability of the writ petition.
You have taken that in your notes also.
But now both respondent number 2, that is the private respondent, respondent number 1, the state, we had both taken the point of maintainability. When the matter was being heard, when the maintainability issue was being decided, my learned friend comes up with an application seeking to insert a prayer for a writ of quo warranto in the writ petition.
Against which the appeal was preferred. What happened to the appeal?
In that application,
Nothing, my lord.
nothing.
Pending.
They do not do
For
it.
last 6 months.
They do
My lord,
do
I am
it.
not asking,
Appeal
but
was
let
preferred-
the appeal be there. my lord. I want final hearing.
Appeal was preferred by respondent number 2. Now, my lord, in that, when that application was prepared, the respondent number 2 raised an objection saying that the writ of certiorari and the quo warranto cannot coexist together. So a hearing took place in that. We all exchanged our affidavits. After that, the Honorable Judge, my lord, was pleased to hold that a writ of quo warranto and certiorari can exist together. There is an elaborate judgment. But the question with regard to the maintainability of the writ petition still looms large. It has to be decided.
So that is going to be.
Why not maintainable? Why do you say not maintainable?
It is not maintainable my lord, on many scores, my lord, because for that, my lord, we have to enter into the factual aspects also.
May I have
on
one,
merits also.
1 minute on that, my lord? My whole, this is very interesting, my lord. Writ of mandamus and certiorari to be, my lord, obtained by a petitioner, that petitioner must be personally interested. In this case, the petitioner must be such that he should have personal entitlement to appointment in the post.
This
That's not
person
his
is not
case.
entitled.
He's not entitled. He doesn't say so, and he's not entitled. So, my lord, he can't get mandamus, he can't get, my lord, certiorari. Now, next, my lord, is quo warranto. For quo warranto, you don't need locus. However, in quo warranto jurisdiction, it's by what authority? So, my lord, your lordship, my lord, will be pleased to direct me to disclose by what authority. I will show, my lord, my authority, my appointment. My learned friend would be entitled to contend that my appointment is contrary to statute. If he can show that ex facie, it's over. But in, my lord, quo warranto, your lordship will not delve deep into, my lord, the sufficiency of, my lord, my qualification. So, my lord, my entire argument would be mandamus, certiorari, no personal right can't be obtained. Quo warranto, my lord, court will not really go into the sufficiency of the appointment. State government considers me to be a Muslim of my lord, the relevant school. I believe Sunni Muslim over here, Shia Muslim, my lord, here. And court will not go into sufficiency of educational
Why are you
qualification.
insisting upon pre-vacation hearing of this?
Lord, I'll tell the reason.
So this is other matter
I'll tell the
tougher,
reason.
basically.
My lord, the reason is, my lord,
Yes.
that insofar as Shia properties are concerned, my lord,
Right.
an opinion is taken, my lord, from the Shia member.
Yes.
Now, my lord, the opinions which are coming, my lord, and what is happening in the state of affairs is such, my lord, that graveyards, my lord, are being, my lord, converted into, my lord, secular properties and, my lord, other properties. So this is the most unfortunate thing. In fact, my lord, off the record, I don't want to prejudice anybody. Opposite my house was an imambara. Opposite my house. I've lived in that house for, my lord, 55 years. They broke it, an imambara, and they converted it into a 6-story commercial place. The Waqfnama says that the entire property is dead. One second.
No, 1 second. This is off the record.
This is what I
You're
want
not
to say.
giving
This is
evidence
the
here.
reason.
Sir,
I'm
let us
sorry,
come
my
back
lord,
on
you're
the
not
new
giving
opening date.
evidence here.
I cannot conclude, even if I conclude hearing, I cannot pass orders within one.
I'll take 20 minutes, my lord. I will not take 22
But this is the motion based before the vacation.
I've
It's
come,
very
my lord,
difficult.
only for this, my lord. Your lordship knows that I've been trying my level best, my lord, only for this.
That's very well. Advance your. You
Lord,
deal with the maintainability point
Will it
and
be, my lord, after a 10-minute break or?
oh yes.
Yes, yes, yes.
Well,
Because
we'll start
your orderly was here.
Yeah, after-
That's the
start
only reason. Greatly obliged. Yes, please. Not those. The section relevant, my lord, pertains to the Waqf Act, my lord.
Waqf sector. Auditor.
This is my book.
আমাদের বইটা খোঁজো।
Waqf Act, sir. I hope it is not marked, my lord.
It's all right.
Yes. No, my lord, the Waqf properties, my lord, are manned by the board, my lord, the Waqf board. But the composition of the Waqf board, my lord, changes, my lord, every 5 years, right? As per statute. Not the category, my lord, of people who are there in for the composition, my lord, are, my lord, either elected members, my lord, or, my lord, nominated members. So, my lord, there's a difference. So as to, my lord, have a democratic mix-up is what the judgment say, my lord. Now, my lord, for your lordship's kind, my lord, perusal, my lord, the composition of elected members 14(1) and, my lord, A to B, my lord, are, my lord, elected members. My lord, like my lord, lawyers, my lord. My lord, a group of lawyers, my lord, they'll elect an advocate who has to be a senior advocate, not necessarily with a gown, my lord. Then an MLA, an MP, a Muslim, my lord, has to be there. Now, my lord, the second category are, my lord, nominated members, right? Now, my lord, they are nominated, my lord, naturally by the state. So, my lord, C says, one person from amongst Muslims who has professional experience in, my lord, and the categories are mentioned: town planning, business management, social work, finance, revenue, agriculture, development. So, my lord, it can't go beyond this. Any, my lord, expansive meaning can be given to social work, etc. But it can't go beyond this, my lord. You can't have a lawyer here, my lord, in the strict sense.
Unless the lawyer also has.
Or unless there's an overlapping thing. Then, my lord, D is what, my lord, is relevant here. D says, my lord, one person each from amongst Muslims to be nominated by the state government, and these are the, my lord, important words for this, the disposal of this writ petition, my lord, from, and the important words are, my lord, recognized scholars in Shia and Sunni Islamic theology. So one person from, my lord, the Sunni school of thought, my lord, and one, my lord, from the Shia, but the qualifying words are, my lord, a recognized scholar, and then, my lord, in Islamic theology, not ordinary theology. My lord, theology, my lord, is a science. As per the Madrasa Education Board, I have annexed the documents, my lord. You have to, my lord, pass, my lord, come to an alim level. The documents are there, just half a minute. Then, my lord, you come to a fazil level, 10 to 12. Then, my lord, you have to pass a BA, then an MA. So, my lord, these are, my lord, the prescribed qualifications which are required to be undertaken if somebody, my lord, wants to, my lord, qualify himself. Recognition, my lord, is another, my lord, composition, my lord, or something totally different, because a mere scholar, my lord, and by scholar I mean, my lord, only a learned person. A mere scholar, my lord, would not also qualify, my lord. There has to be some sort of recognition. And recognition, my lord, according to me, and what has been held at least by 2 high courts of this country, my lord, is that, my lord, by way of publication of articles, books, or, my lord, by authorities, my lord, who hold, my lord, some sort of, let's say, my lord, power, my lord. And that is, at least there are 2 judgments which say that those are the persons who are recognized. So ordinary scholars also, my lord, will not qualify. This is, my lord, the genesis. And of course, the E would be from Muslims to be nominated by the state from amongst the officers of the state government, not below the rank of a joint secretary. So, my lord, anybody who is below the rank of a joint secretary, my lord, and says, I will be promoted, I should be considered, that cannot be.
Your present grievance is only with regard to D.
D, my lord. That's all. But what I want to emphasize is, my lord, that the mixture, my lord, has, my lord, come because of a thought process.
Yes.
The legislature in its wisdom thought, my lord, that the composition of a work board must be such as to, my lord, for those members to address a particular issue in the correct perspective, my lord. Now, my lord, I'll come straight away, my lord, to the dates, my lord, which are relevant. So there is a notification, my lord, by the my lord, by the Ministry of Minority Affairs, which is dated 28/1/2022 in the list of dates, my lord, I've given. About that, my short notes. My notes, which was given to the Honorable Court. Now, this, my lord, is at page 21.
Yes.
Of the my lord, of the paper book. My lord. No, this is not. Our it.
Yes.
I'll try to be, my lord, as fast as possible. I know, my lord, that
No, no, it's all.
that the and I'm greatly obliged for your lordship, my lord. No, my lord, this notification is at page 21.
Right.
My lord, is published, my lord, by and my lord, Gazette notification, Ministry of Minority Affairs, my lord, if your lordship has it, middle of the page.
Yes.
And my lord, date is 28 January. And third last line, Governor is pleased to reconstitute.
Yes.
My lord, the board period, it expired, my lord, on 16/1/2017. The para just above that. And so, my lord, 16/1/22 was the next 5-year period. Now, your lordship may kindly see page 22, the elected members, and A, B, C, D, my lord, all say to be notified later. So, the election process has to take place. They'll elect among themselves the electoral body, my lord. Then members nominated by the state. So, my lord, this is the category. Persons from among Muslim who has professional experience at 14(1)(c), which I read, my lord, from town planning, business management, social, so and so, Janab Muhammad Abdul Ghani. He is nominated, my lord. Then the 14(1)(d) is, my lord, capital B. One person from each amongst Muslims from recognized scholars in Shia and Sunni Islamic theology under section 14(1)(d), and for the Sunni sect, my lord, they say, Janab Qari Fazlur Rahman. Now, Qari, my lord, is somebody who knows, my lord, subject to correction, the Quran by rote, my lord, and can also interpret. So, for the Sunni sect, my lord, the Qari is selected. And prior to this, my lord, prior to the second respondent, my lord, being nominated, all along, my lord, for the Shias, my lord, all along, there was, my lord, somebody, my lord, who was a theologist in the true sense of the word. So, my lord, Janab Humayun Ali Mirza. He is, my lord.
So the bone of contention is Janab Humayun Ali.
And this, my lord, this nomination, my lord, did not come, my lord, by calling for, my lord, inviting other peoples, etc. It was just a pick and choose policy. Somebody came, nobody knows what's happened behind the curtains. What documents are given, how were they appraised, nobody knows, my lord. My lordship may kindly see, my lord, that a group of persons, my lord, all belonging to the Shia sect, my lord, they give representations, my lord, to the authorities concerned, that this man does not, my lord, have the necessary qualifications, which representations are, my lord, pages 24, my lord, and 30. And these are the petitions before their lordship. Because, my lord, the right, my lord, to have, let's say, a proper trustee or a proper person, my lord, to be your representative is an inbuilt right, my lord, within the community. And then, my lord, the page 24 and 30, my lord, are the two annexures, P2 and P3, where we
They're by
say,
individuals, by ordinary individuals.
they are members of the Shia members.
Obviously, they
yes,
have to.
yes.
Right. Very.
So they say, my lord, in fact, page 25 is, my lord, the middle of the paragraph, that the nomination procedure so prescribed is to be strictly followed, if your lordship has that, my lord.
Yes, yes.
Then, my lord, the next paragraph, aforesaid notification under reference, so and so Humayun Mirza. My client state that said Humayun Mirza has no knowledge of Islamic theology and cannot claim to be a scholar, let alone a recognized scholar. To the best knowledge of my clients, he is not even a graduate. And then, my lord, that the nomination is on a pick and choose policy without following the act. And the last line of the same paragraph, completely erroneous interpretation of section 14(1)(d).
No, is there a procedure for choosing?
My lord, what has happened in the past, my lord, the ministry will say, my lord, is, my lord, they, my lord, put up on the notice board, my lord, that the process has come to an end, because this is nomination. For election, the electoral body for advocates or for MLAs or for MPs, a small body is there. But for this, my lord, they always paste it out. And, my lord, and there has to be or should be, my lord, a notification inviting application, because the best man has to be taken, or somebody who, my lord, is the best among the rest.
But that is not there in the statute or regulation.
My lord, I'm not too aware of the rules of notification, but it's not in the act. It's not in the act. Now, my lord, if your lordship may kindly see, my lord, since these representations went unanswered because they don't want to reply, I had to file a writ, my lord. The writ was disposed of, my lord, to consider the representations. This was by my lord. The first writ was WP number 5493, and my lord, the order was passed by this honorable court on, my lord.
We're not going to that.
Yes, 29.
There was a direction.
Correct.
After that, what?
After that direction, my lord, the representation, my lord, we were called, my lord, and there is an annexure P8, page 84. The representation, since we were called, Humayun Ali Mirza did not appear. So, my lord, he does not appear, my lord, before the authorities. He wants to play hide and seek because he'll be asked to call for his credentials or substantiate his claims. Then, my lord, 2, the ministry cannot appoint anyone in absence of proof of eligibility. 3, requirement of section so-and-so cannot be diluted.
What is this meeting held at 11:30?
Because the honorable
Meeting among whom?
No, the honorable court, my lord, the learned judge said, my lord, you make a representation, meet them, and go to the authority concerned, go to the ministry. That 14(6) order is what I wanted to read.
So here there must be the signature of some person
No,
from the ministry also then.
The 5 people, my lord, who made the representation, my lord, they give this letter again, and the meeting and the decision was taken on the next day. This is, my lord, my letter as to what happened on the 18th, because Humayun did not come. So I gave a representation that he did not come, and the requirements of the section are not met.
No, this meeting was held between whom?
No, this is a letter, my lord, which
you referred to a meeting, the reference of that letter. That was between yourselves.
No. The meeting, my lord, when the writ was disposed of,
yes,
the court, my lord, directed that you have a meeting on such and such date.
You means among yourselves?
No. My lord, all parties, the board, my lord, Humayun Ali Mirza, and my lord, the ministry.
The meetings, the minutes of the meeting must be there
Yes,
also.
yes, yeah.
So somebody was there from the state also.
Yes, my lord.
That means where is that annexed?
No, the next page, my lord.
Oh, there.
P9, page 85.
The next page is subsequent to that.
Is subsequent to that. What happened on the 18th, my lord? We just recorded it.
18th of July, you have spoken of a meeting held at 11:30 on 18th of July.
Correct.
In terms of order of honorable court.
Correct.
But the meeting is held subsequently.
No. The decision is taken subsequently. We only said that this was what was done at the meeting. So and so did not appear, and we gave our representation.
Good.
So the decision was taken subsequently, just to record what
After
happened.
the meeting, you put something on record.
That.
Very.
Yes. I'm sorry, my lord, I could not explain.
No, I understand. Yes.
Now, my lord, what the decision show taken, my lord, on 27/7/22.
Now you are basically challenging this decision.
This decision. And the earlier notification, my lord, because this follows the gazette notification.
Yes.
And, my lord, what we have stated are, my lord, reiterated in the last 2 paragraphs. I don't want to trouble your lordship. What we say is that they have also submitted the last line is not even remotely connected to Islamic theology. Now, my lord, before dealing with the submission of the petitioner, he quotes the section. He's the secretary, my lord, I believe. Secretary. So from the above provision, it is clear that to be nominated in the category of a recognized scholar in Islamic theology, it is not compulsory to have a degree of Islamic theology from a recognized educational institution. Janab Mirza is a Nazir. Nazir is like a Mutwalli, of Basravi Waqf estate appointed by the court to look after the biggest Shia community mosque. He is a member of the West Bengal Hajj Committee under the Hajj Committee Act so-and-so and Mutwalli of estates. Working experience in administration of Waqf matters is also important. Janab Mirza also has huge experience in administration of Waqf matters. He has been nominated, being satisfied of his credentials as per provision of section 14(1)(d) of the Act. So it cannot be challenged that he does not have any formal degree. My lord, it doesn't say anything. Not a single word, a scrap of paper, any article, anything which, my lord, weighed in the mind, my lord, of the authorities concerned as to whether he is even somehow connected to theology. A Mutwalli will do what, my lord? He'll make the accounts, he'll see the repairs of the mosque. That's the maximum he'll do. In the Hajj committee, he'll see who all are going for Hajj. Are they entitled or not entitled? But theology, my lord, and there is literature to that effect, it's a science, my lord. It's a complete science. I have annexed those documents. It's not, my lord, it's not so simple, my lord. Those documents I'll relate to. Now, my lord, after this decision was challenged again, my lord, by way of a writ petition, the present writ petition, my lord. And if your lordship may kindly see, my lord, the grounds also are there, which are, my lord, from page 9 onwards. In fact, if your lordship may give a little indulgence, my lord, then I'd just like to read, my lord, page 6, my lord.
Yes.
My lord, page 6, my lord, I just want to say, my lord, para 7. Your petitioner says that the nomination of respondent number 2 so-and-so is per se illegal and an abuse of administrative power, smacking of malified exercise of authority. There is also likely to arise serious conflict of interest as the said respondent number 2 is mutawalli in several works and there are controversies regarding his decisions in relation to such works. It is stated that in at least 2 Waqf estates, the said Humayun Ali Mirza is FIR named and facing criminal proceedings for illegal alienation of work properties. The petitioners crave leave to FIR number 30 and 98 at the time of hearing. My lord, I have annexed, my lord, copies of the FIRs, my lord, where, my lord, in the Nazir, where he is a Nazir, my lord, a shop was sold. And so that is pending. And 98, my lord, relates to an Imambara which was demolished. And my lord, a market complex was built over there. The Waqfnama says, my lord, the entire property will be used as a Waqf, as my lord, as the Imambara, but he, my lord, reserved it on the 3rd floor as a private Imambara. So that public nature, etc., he changed. I don't want to prejudice anybody, my lord. I'm just saying today, my lord, that these things also, my lord, were, my lord, thought of, my lord, and, my lord, incorporated in the order passed by, my lord, another learned single judge of this court, my lord, as to the status of the FIRs, my lord. No, my lord, para 8, my lord, are the same two representations, my lord.
What is the current position of that those criminal proceedings?
Pending, my lord. No. One, my lord, in the second one, my lord, because there was deviation, etc.
Yes.
So currently, he has made a payment of, I think, 80 lakhs or something currently to regularize, which is also pending the regularization process. I am told, my lord, is pending because that happened after 10 years' time. And the first one, my lord, the Honorable Justice Joymallah Bakchi, my lord, he, my lord, said that the Narazgi petition was there. So he said, continue with the investigation. So both are pending. Yes. And my lord, if your lordship may kindly see, my lord, the grounds. Grounds are at page 9. And there are repetition, my lord, of what was stated. So it does not meet eligibility criteria, not recognized, not a scholar, etc., etc. They are, my lord, short and simple grounds from A to G, my lord. And then, my lord, the prayer was there, my lord. So these members, my lord, they came up and said that this man, my lord, does not fulfill the criteria. So a writ may be issued, my lord. The nomenclatures are there, my lord. Certiorari, etc. Call for the records, check it. Certiorari, my lord, your lordship knows, my lord, well away. Just see, my lord, and demolish. My lord, this, my lord, was heard on different dates. And, my lord, there's an order of this honorable court, my lord, of 1st of September 2022, my lord.
Yes.
No, my lord, this is the little history at page 1, my lord, and then page 2.
Yes.
They challenge the locus, etc. Main objection on behalf of the private respondent, the second paragraph on the top, is that he fulfills the eligibility criteria and the petition must establish locus. So this is what.
Where is that Quaranto and
the last order
that was resolved?
That
saying that both can be maintained. Against which that appeal is
a detailed judgment.
What is the date of that order? What is the date of that order?
14th of June.
June 2023. It's a quite a detailed order. That was in Can 1 of 2020.
14 June টা বাদ দিয়ে সব রয়েছে তো এখানে।
Do you have an extra?
অর্ডার গুলো শুধু সেলাই করে রাখার কথা, অর্ডার গুলো খোলা আর এমনি অন্য কাগজ সেলাই করে। অর্ডার গুলো সই very good. So yes, what is your main argument on merit?
Yes, I'll say that. But this order of my lord, 1st September said, my lord, you bring clarity on the FIRs. And, my lord, the basis of the nomination and the number of persons considered, on which, my lord, the affidavits are, my lord, completely silent.
Oh, I see.
Insofar as, my lord, the second is concerned, basis of the nomination made as well as the total number of persons, completely silent.
And show this also.
On that.
Affidavit in opposition.
Basis of nomination and number of
persons considered.
Considered.
That was a specific direction, my lord, by this honorable court. So, my lord, that there is nothing on record, my lord, not a single line as to who all came in the fray and how it happened.
They can just congratulate him.
So, my lord, then affidavits or exchange, I'll just, my lord, give the relevant pages of the affidavits, my lord, what they said. I'm so sorry, my lord, I'm taking half a minute more, my lord. That's all. My lord, the first affidavit in opposition, my lord, filed by the state, my lord, 9th September.
No, this is to show that it was silent on these two aspects.
On these two aspects.
You are placing the affidavit in opposition for that purpose.
On that.
Let them show that it is
I see.
there.
I see.
A negative proof you need not prove.
So, my lord, the number of persons considered pick and sue is avoided. They don't answer that question, which is the affidavit on behalf of the state, which was a specific requirement, 9th of September,
Yes.
2022.
Number 2.
And, my lord, for the respondent number 2 also, my lord, he goes a step further, my lord.
Yes.
He says, now there are congratulatory messages, my lord, which are prior in time. How he manages his thing, my lord, your lordship may kindly see page 23 of the affidavit affirmed on 22nd September by respondent number 2.
28/1/2022 is the notification nomination, and this is 7/12/2021.
So, my lord, this date, I want to say how documents are created, page 23.
When was he appointed? Is there any date given by?
My lord, my lord, he was nominated on 28th of, my lord, January 2022.
28th January.
28th January. And the congratulatory messages, my lord, they follow earlier. Your lordship, it is 7/12/2021.
Page 23.
It is before.
Next to the opposition.
They have. Page 23.
Yes. All right. Yes.
And your lordship will then know from this document as to what is the flow of and the mindset, my lord. The FIR, my lord, he annexes one of them with page 30. Page 30 is one of the FIRs, my lord. So there's a charge of, my lord, in the same mosque where he's a Nazir, that 40 lakhs, my lord, has been, my lord, defalcated. Page 30, the last paragraph.
Where is the complainant there? Or are you connected with that complaint?
No, I'm not. No. The person's there and they are totally different.
Great.
And the other FIR, my lord, I spoke about that regularization. It's just been regularized, my lord. He made a market complex. And
I want to rule out the personal angle also.
No. There's none, my lord. There's none.
Good.
Now, your lordship may kindly see, my lord, I'll not trouble your lordship with these affidavits. They are, of course, on locus and maintainability. I'll answer those questions, my lord. Now, but this order which your lordship, my lord, correctly wanted, of 14th of, my lord, June, sorry. A little bit of reading, my lord, will be important. The writ of quo warranto, my lord, it is so, insofar as my reading limited knowledge is there, my lord, I'm always open, my lord, to correction, is that the rules of locus, my lord, are relaxed. The person who comes up and says, my lord, is that, look, this is a public office. This man, my lord, is not eligible. He's not eligible. He does not have the criteria. I bring it to the notice of the court. I am in the position of.
There are certain judgments also.
There are a number.
4 and 2 habeas corpus.
Yes.
In these two cases and in public interest litigation, these are the general exceptions.
The locus.
Yes.
But, my lord, I also cited a judgment, my lord, by a 7-judge bench, my lord, where even for certiorari, my lord, and it is quoted with approval, my lord, in this judgment, that even in certiorari, my lord, it is an action actus propriando. And, my lord, it does not require locus in the strict sense. Those were, my lord, quoted with approval, my lord, by the learned judgment. Now, my lord, I'll just read. Since, my lord, should I, my lord, for a minute only read the article 226, my lord, because how it is framed, my lord, and the widest amplitude, or should I go to the judgment, whatever, my lord? Your lordship must have read
the
it.
Judgment, in its entirety, you need not place. I mean, the
I'll
judgment speaks for itself.
Correct. The judgment.
So this is your justification.
No, my justification.
If your arguments have been recorded here,
they have been.
And the judgments you cited are recorded here, I'll go through this judgment.
Correct. No, only, my lord, what my lord, article 226 says, my lord, and what the learned judge. learned just
Let
said.
me place that relevant
Yes.
portion.
No, it was only for the amendment part of it. But my lord, my lord, the lady, my lady, my lord, she gave some sort of observations there also, my lord.
Right.
So, my lord, the
The
judgment
amendment was opposed on the ground that two cannot coexist.
mutually destructive. So that has been negated. They say they are mutually destructive on some sort of a collision course.
But ultimately, that boils down to that amendment only.
Correct.
So it's not a final statement on whether in this case one or two is maintainable.
No, it's not. It is because the honorable judge Miller says
This question, as of today, I cannot reopen unless it is set aside in appeal.
Correct.
So we cannot reopen this chapter. I cannot reopen
The
this
amendment part
being
of
a
it, my lord, today, my lord, the amendment
Yes.
starts, my lord, the rate has been inserted.
Yes,
my lord.
exactly.
It is there. That
So-
part
so-
of it is there.
Yes, I don't think this is required to be gone into.
But the only thing is, my lord, the honorable court, my lord, the learned judge, my lord, thought, my lord.
Yes.
And my lord, we delved on, my lord, the amplitude, my lord, and the scope of Article 226.
All right.
Because, and that is why, my lord, I just want to read it for half a minute.
Please.
Just read the Constitution.
Yes, which part?
Article
Oh,
220.
Constitution, sorry.
She must have quoted.
Yes.
No, may I read? Notwithstanding anything in Article 32, every High Court shall have power for the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government, within those directions, and these are the important words, my lord. Within those territories, directions, orders, or writs. So it's not necessary, my lord, that a person will come up and file a writ. The Supreme Court has said, my lord, and there are 2-3 judgments, they say we will pass directions. So the option, my lord, is given. It's not necessary that person comes up and says, this is the writ in the nature of so-and-so, like the fanciful words are there. It's not required. Writs including, and this again is important, in the nature of, they don't say writs of habeas corpus. No. In the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them, for the enforcement of any of the rights conferred by Part 3 and this again is important, for any other purpose. So the important words I said, my lord, were direction, orders, or writs in the nature of, and, my lord, for any other purpose. And this is, my lord, there was a few judgments cited, my lord, which were approved, my lord, by the honorable ladyship, my lord. Now, my lord, if your lordship may kindly see, my lord, what I did cite, my lord, on this, and they are part of, my lord, the compilation which I handed over. Well, my lord, four, my lord, very important judgment. In fact, 6 of them. I will, my lord, only, my lord, highlight the paragraphs, my lord. If your lordship wants me to read it, I'll read it, my lord. I don't want to waste the court's time, my lord. But the first one is at serial number 7, the scope of Article 226, my lord, in the compilation. Sorry. It is, my lord, AIR 1954, Supreme Court 440. And, my lord, the compilation begins at page 130.
Yes, got it.
Yes. Now, this was an election dispute, my lord. There's some corrupt practice involved, my lord. And the grievance was to the election commissioner, and prayer was for certiorari. Now, my lord, your lordship may kindly see, my lord. I have in the index, my lord, I don't know whether I mentioned it or no. The relevant paragraphs are 5, 6, 7, and 11. I'm not too sure, my lord, if those paragraphs are mentioned in the
No, I'll
index.
just take a note of that.
So it's, my lord, 5, 6, 7, and 11. Correct. So, my lord, I don't want to read the whole paragraph. The principles upon which superior courts in England interfere by paragraph 5.
This is for which proposition?
This is, my lord, my lord, certiorari, my lord, where writs of certiorari would lie, my lord, already. And, my lord, also the language, my lord, of Article 226, my lord. Well, the last 4 lines, my lord, in paragraph 5, I'll read, my lord, the states fear new and wide powers on the high courts of issuing the last 6 lines, my lord.
Got it. Yes.
Directions, orders, or writs primarily for the enforcement of fundamental rights, the power to issue such directions for other purpose being also included with a view apparently to place all high courts in the country in somewhat the same position as the high courts, King's Bench in England. Now, the language used in Article 32 and 226 of our Constitution is very wide, and the powers of the Supreme Court as well as of the high courts in India extend to issuing of orders, writs or directions, including writs in the nature of, again, Lord, habeas corpus, mandamus, quo warranto, etc., considered necessary for enforcement of fundamental rights, and in the case of the high courts, for other purposes as well. In view of the express provision in our Constitution, we need not now look back in the early history of the procedural technicalities of these writs in England law, nor feel oppressed by any difference or change of opinion expressed in particular cases by English judges. We can make an order or issue a writ in the nature of certiorari in appropriate cases and in appropriate manner, so long as we keep all the broad fundamental principles that regulate the exercise. One of the fundamental principles in regard to the issuing of a writ of certiorari is that the writ can be availed of only to remove or adjudicate on the validity of judicial acts. Now, my lord, the expression judicial acts include the exercise of quasi-judicial function by administrative authorities or other authorities or persons obliged to exercise such functions, and is used to contrast with what are purely ministerial acts. So, my lord, the appointment, my lord, required some application of mine, my lord, and was not a purely ministerial act.
There's a larger aspect also, probably. Waqf board also has certain quasi-judicial powers.
Yes, yes. For
that be so, if you are appointing a member of that board, I mean, if he exercises ultimately quasi-judicial powers, so that can be read into probably the appointment also.
Correct.
Because this person ultimately will be exercising
yes,
that.
no, there are a number of
one of the persons.
There are a number of.
Very.
Your lordship is perfectly right.
Yes.
And my lord, the law was summed up in Rex versus so and so. I don't want to, my lord, read the entire part, except, my lord, the fifth line from the bottom.
Yes.
When it's at the corner of the right, on the right side, it demolishes. While speaking on the writ of certiorari, para beginning, the second essential feature is that the control which is exercised. I don't want to trouble your lordship. The last 5 lines, it demolishes the order which it considers to be without jurisdiction or palpably erroneous, but does not substitute its view. So you bring the order, you demolish it, but will not substitute our view. For those of the inferior tribunal, the offending order or proceeding, so as to say, is put out of the way, as one should not be used to detriment any other person. My lord, the second judgment, my lord, because this was 54, then Dwarka Nath, my lord, page 143 of the compilation, and paragraphs, my lord, I'm so sorry again, my lord, are 3, 4, and 5, your lordship. The citation is 1965, 3 SCR, 536.
Yes.
Lord, in this judgment, again, my lord, writ of certiorari, and my lord, what is a judicial act? Were, my lord, considered, and it was held that it is not necessary that it might be a court.
Obvious.
Yes. So, my lord, para 4 says, my lord, any person or authority. And para 4 is what was quoted by the honorable judge, my lord, also. So, my lord, I'll just a little reading, my lord. We shall first take the preliminary objection, for if he to maintain it, no other question will arise for consideration. Article 226. Here, my lord, the preliminary objection was there, my lord, that regarding income tax tribunals and administrative track, etc. So that is at para 3. And, my lord, the court holds, my lord, quote, the article is quoted, and what the finding of the court, my lord, this article, because this is, my lord, quoted it with, my lord, approval in several judgments. This article is couched in comprehensive phraseology, and it exercises a wide power on the high courts to reach injustice wherever it is found. The Constitution designedly used a wide language in describing the nature of the power, the purpose for which, and the person or authority against whom it can be exercised. It can issue writs in the nature of prerogative writs as understood in England, but the scope of those writs also is widened by the use of the expression nature. For the said expression does not equate the writs that can be issued in India with those in England, but only draws an analogy from them. That apart, high courts can also issue directions, orders, or writs other than the prerogative writs. It enables the high courts to mold the relief to meet the peculiar and complicated requirements of this country. Any attempt to equate the scope of the power of the High Court under Article 226 of the Constitution with that of the English courts to issue prerogative writs is to introduce the, importantly, unnecessarily procedural restrictions grown over the years in a comparatively small country like England with a unitary form of government to a vast country like India functioning under a federal system. Such a construction defeats the purpose of the article itself. And my lord, para 5 is there. I will not trouble you. I always, my lord,
try not to trouble.
No, try not to trouble and not cut short the time. Sometimes in the Supreme Court, my lord, we get 1 or 2 minutes. Put your point. If it's there, it's there.
Yes. Very good.
My lord, para page 146, fifth line. The question. Page 146.
Yes.
The question whether an act is a judicial act or an administrative act arises ordinarily in the context of the proceedings of an administrative tribunal or authority. So, what is a judicial act? The lordship knows.
Yes.
And then, my lord, the quotations are there. I will not, my lord, trouble your lordship.
So the keywords in Article 226,
yes,
which you are relying on, are in the nature of and for any purpose.
Other purpose, my lord, then there was.
Right.
And my lord, after Basappa, there's one, my lord, Andy Mukta, my lord, that's serial number 9. The relevant paragraphs are, my lord, 15 to 20. I'm so sorry again, my lord. If your lordship want, my lord, during the.
No,
I'll
I'm doing that.
I'm so sorry.
Yes.
So the citation is 89 to SCC, page 691. And my lord, page 153 to 163. This, my lord, gives a historical perspective of the writs, my lord. It's 89. This is much after, my lord, Basappa and Dwarkana. Page 1. So that's
wide language and all.
Wide language, etc. And something in relation to mandamus, my lord, and what happened in England, my lord. English people also, my lord, they also became wiser after the other.
Yes.
And my lord, the para 16 onwards, my lord. Page 160.
Some of the judgments have been quoted.
Yes, I will not. Yes. Para 16, my lord. This is what happened, my lord. The law relating to mandamus. I've explained certiorari in the other judgments, my lord. Para 16, may I read for half a minute, my lord?
Yes.
The law relating to mandamus has made the most spectacular advance. It may be recalled that the remedy by prerogative writs in England started with a very limited scope and suffered from many procedural disadvantages. To overcome the difficulty, Lord so-and-so in persons of so-and-so requested the Law Commission to review the existing remedies for the judicial control of administrative acts and omissions with a view to evolving a simpler and more effective procedure. The Law Commission made their report in March so-and-so. It was implemented by rules and given statutory force in so-and-so. It combined all the former remedies in one proceeding called judicial review. Lord Denning explains the scope of the judicial review. At one stroke, the courts could grant whatever relief was appropriate. Not only certiorari and mandamus, but also declaration and injunction. They possibly borrowed our word, declaration. Yes. So we contribute a little bit there also.
Yes,
apart from the Prime Minister.
Two-way traffic.
Yes. Even damages. The procedure was much more simple and expeditious, just a summons instead of a writ, no formal pleadings, etc. The second paragraph, my lord, beginning the statute. And my lord, the fifth line. So the previous law as to who are and who are not public authority is not an absolutely binding, nor is the previous law as to matters in respect of which relief may be granted. This means that the judges can develop the public law as they think best. That they have done and are doing. Now 17. 17, my lord, the first 6 lines, I will not trouble your lordship. They are in relation to public authorities and to compel performance. Line beginning, but. Fifth line, but. There is no such limitation for our High Courts to issue the writ in the nature of mandamus. Article 226 confers wide powers on the High Courts to issue writs in the nature of prerogative writs. This is a striking departure from the English law. Under Article 226, writs can be issued to any person or authority and for any other purpose. And then, my lord, this is quoted. I don't want to trouble your lordship again, my lord. Number after Andi Mukta, my lord, there is a serial number 10. They follow the thing. Your lordship may just make a note of it, my lord. The relevant page is, my lord, para 13 and at 171. Serial number 10, my lord. Page 164 onwards. So, it's 169, 2 SCC, 262. Para, my lord, 13, 262. So the mutually destructive argument goes, my lord, because all right. Here, my lord, para 13. Page 170.
Yes.
The dividing line, your lordship. The dividing line between an administrative power and quasi-judicial power is quite thin and is being gradually obliterated. For determining whether a power is an administrative power or quasi-judicial power, one has to look into the nature of the power. I will not trouble your lordship, my lord. After about 8-9 lines, the requirement of acting judicially in essence is nothing but a requirement to act justly and fairly and not arbitrarily or capriciously. The procedures which are considered inherent in the exercise of a judicial power are merely those which facilitate, if not ensure, a just and fair decision. In recent years, the concept of quasi-judicial power has been undergoing a radical change. What was considered an administrative power some years back is now being considered as a quasi-judicial power. I don't know whether it's quasi or quasi, I'm not.
Depending on the court which you're addressing. It's like semi. Entirely dependent on the court which you're addressing. So here, quasi is okay.
Quasi is...
Quasi, both.
You try to make it simple.
Yes.
Well, the same page, I'll just continue with the second last paragraph.
Yes.
The position, as I see it, is that the exact limits, if your lordship, of the ancient remedy by way of certiorari have never been and ought not to be specifically defined. They have varied from time to time, being extended to meet changing conditions. At one time, the writ only went to an inferior court. Later, its ambit was extended. Later, again, it extended to cases where there was no list in the strict sense of the word, but where immediate or subsequent rights of a citizen were affected. The only constant limits throughout were that it was performing a public duty. And then the last paragraph, finally, it has to be observed that the remedy has now been extended to so-and-so cases, my lord. Just over the page, my lord, page 172, we have, as it seems, if your lordship has it, my lord,
yes,
reached the position where the ambit of certiorari can be said to cover every case in which a body of persons of a public, as opposed to purely private or domestic act, has to determine matters affecting subjects, provided always that it has a duty to act judicially. So, my lord, we were subjects, my lord. Now, my lord, I don't want to reiterate, my lord, at serial number 11, my lord, the citation 1969 1 SCC 585, where, my lord, a writ of declaration was, my lord, granted, my lord. Para 8 is the relevant paragraph, my lord. Starts at 177. Para 8 would be, my lord, at page 182. Yes, my lord, I'll not read the whole thing again, my lord. Lord, just about 10 lines from the bottom. It's even about 10, 12 lines. Even where the statutory power of dismissal, this was a labor dispute, my lord, is not made subject to express procedural requirements or limited to prescribed grounds. Courts have granted a declaration that it was invalidly exercised if the authority has failed to observe rules of natural justice. And then after about 5 lines, my lord, such a declaration can be issued against a person or an authority or a corporation where the impugned act is in violation of or contrary to a statute under which it is set up or governed, or a public duty or responsibility imposed on such person, authority, or body of persons of a statute. And, my lord, the writ of declaration was followed, my lord, in the subsequent very recent judgment of 2013 at serial number 12, my lord, where the eligibility criteria was not prescribed, my lord, but my lord, it was reiterated. The paragraphs are, my lord, I'm so sorry, my lord.
No, you have mentioned here. The back.
From
50, 51,
yeah.
89.
Yeah.
90.
The citation is 2013 5 SCC 67. No, my lord, for quo warranto, my lord, it was quoted with approval, my lord. The order of 14th of June is there. I have cited, my lord, in the index, my lord, 4 judgments as serial number 13, 14, 15, and 16, my lord.
Yes.
Where the important thing was that it should be a public office, my lord. Rules of locus are not required. I've mentioned the paragraph, my lord. Before the holidays, my lord, I don't.
Yes, please. Because the other matters are also there. Yes.
So, my lord, at writ of quo warranto, the lead judgment was the first one, my lord. University of Mysore versus C.D. Govindarao, my lord, is the lead judgment. Paragraph, I hope the paragraph is there.
Paragraph 6.
6. And for the next one, my lord, are 10.
19, 30, 31. You have given all the paragraphs.
Yes, my lord. Kindly insert, my lord, 16 in between 10 and 19.
Which one? 10 and 19.
The index there.
2013 1 SCC 501.
I'll give an index. There's a separate
I think it will be easier for the.
I'll give an index. I
At
think
least
I
give
have
an
a
index.
compilation. If they can share the compilation, it will be
Yes, yes.
subject to payment of cost. Your lordship said-
Absolutely, absolutely.
Yes.
Double payment.
Yes. We shall do.
The state will pay.
Yes. So now, my lord, the first ones I say, my lord, words of a legislature can't be said to be in waste. That a part, the first 4 judgments. Lordship knows, my lord, it can't be in waste.
I'll look into that.
If they say, my lord, the prescribed criteria, you have to meet the prescribed. You can't say, my lord, I am X and Y. If you want a lawyer, you can't give a doctor. Or a compounder, my lord, cannot become a doctor. Or an intern cannot be termed as a lawyer. He's still an intern. He has to pass the bar council exam. My lord, those 4 judgments are there. And, my lord, since, my lord, quo warranto required, my lord, my learned friend may argue, my lord, as to the nature of the office, because it has to be a public office. No, my lord, your lordship said, my lord, that board members would also be exercising quasi-judicial powers, my lord.
Yes.
So, my lord, the Waqf board, my lord, by any stretch of imagination, is not a private body. It's a public body. The functions, my lord, are there, my lord, to, my lord, supervise all the Waqf estates.
It's a statutory body. Actually.
It is. This is under the statute, under the ministry.
Yes.
So, my lord, I don't think, my lord, I have to say, my lord, that, that members of the Waqf board, my lord, are not, my lord, public officers. Whatever it is, what the judgments which I say, my lord, is the nature of work you do.
Yes.
It's always dependent on the nature of work. So what the judgments say also, my lord, there is no, my lord, straitjacket formula. You just see who is the member and what is the work he is doing. So, my lord, for those, my lord, I have said, my
Public
lord,
office need not necessarily mean a government servant.
no, that is the argument, my lord.
We are not government servants as
Correct.
such. We have been appointed by the president, but we are doing public. We are in a public office. I mean, broadly, it can be imported many.
Yes,
in many
and
places.
they have been in several judgments, my lord. They have been.
There are judgments.
There are. I've tried
They
to
must
cite
be
a
dealing
few.
with that also.
I've tried to cite a few. So, my lord, I will not trouble your lordship with serial A 1 and 2.
Yes.
And, my lord, what I say, my lord, at B is there is no free will to appoint. You can't have an unfettered right. I am the state. I'll appoint anybody. That in nomination, my lord, particularly when you know that what
So the guideline of the act has to be followed.
has to be
Recognized, whatever Islamic scholar.
to the T, my lord. To the T. In fact, theology, in fact, also begins with T. A little lightheartedness is always better.
Yes.
So, my lord, free will to appoint is not an
So
unfettered.
they have followed to the T, but they did not. It ends
the
with a
other
Y.
part of it, HEUL.
It ends with a Y. That's why they didn't follow after T. Anyway,
So,
so
my lord, the free will to appoint as index B, free will to is not an unfettered right. The paragraphs are, my lord, 8, 21 and 29. First page, my lord. 8, 21, 29. And, my lord, the second is, my lord, paragraph 14.
yes.
And, my lord, for my lord, satisfaction of this court, my lord, and also, my lord, if we could enhance, my lord, our knowledge also. I've cited 2 judgments, my lord, public nature of office, my lord. So this I could find, my lord, essentially one, which
Do
is
they deal with the Waqf board?
no, my lord.
Something
But they
else.
just say, my lord, what
Principles.
is a public office? So, my lord, I'll just trouble your lordship with 2 pages, which are pages 93 and 94, my lord, of the compilation. This was, my lord, in relation to a syndicate, etc., of a college, etc., and the government, my lord, also having being an aided.
D for Bombay. This is B. C. Serial number 5. But it's 59.
Just Acha. That must be noted. Your lordship may kindly see, my lord, I'll have my colleague, of course, will give the page 93, my lord.
93.
The last two lines.
Yes, I'm looking from there on.
It is next considered that members of the syndicate of the Madras University are not persons holding public office within the meaning of section so and so of the specific defect, and that the remedy, if any, is against the Senate. Although the word public servant has been defined in some acts, for example, the CPC and the Indian Penal Code, there is no definition of the word in the General Clauses Act. Public office, I take it, means any office created by the legislative or other lawful authority for the purpose of discharging functions which affect the public generally or any particular section thereof. The University Act created a public body to carry out certain defined public objects. I'll not trouble your lordship again, my lord. And then, my lord, the learned judge comes to the finding. I find it difficult to see why members of a statutory body so constituted are not persons holding a public office. And then, my lord, the same page, my lord, it is argued by the learned advocate general that the public officers should receive emoluments, etc., were appointed to discharge a public duty. That had been the argument that you have to have some sort of emolument. So, my lord, the last 5 lines, this definition is not exhaustive. Courts to England have issued a mandamus against poor law guardians, town councillors, church wardens, and other purely honorary public officers.
Do the board members get any remuneration? Honorary?
When they go, my lord, and per meeting, my lord, is what I am told, my lord, subject to correction, is that something is given. Apart from tea and coffee, something.
Do it gratis, I mean.
I believe so.
Good. Anyway,
yes.
The test is, the last line, is not whether a man receives any emoluments, but the nature of the acts to perform which he is appointed or which he is legally liable to perform. So everything is public, my lord. He doesn't go over there and say, all work, my lord. Your lordship knows the act itself speaks for itself. All the functions are there, my lord.
The interests of an entire community are represented in the, I mean, the aspirations of the community are reflected to the.
On that one man.
No, not that one man, the entire board.
Yes, my lord, the board. Correct. No, for us, my lord, because he represents us, and in respect of Shia property.
Oh, yes, you are right. I'm sorry.
Yes.
He's the only representative of the Shia. Oh, yes, you are right.
And it is his word which will carry.
I'm sorry. Yes,
there's a particular section to that.
For that community, he's the.
Yes. And Lord, the other judgment is there, Bini and other, my lord, as a body performing. I've given the paragraphs 9, 11, serial number 6, public nature of.
Yes.
9, 11.
29.
And before 29 or 23, if your lordship wishes to read it.
All right. Yes.
And my lord, on the eligibility criteria, now we come to the crux of the matter. The basis I've given, my lord, I tried to, my lord, explain the locus part of it, etc.
Yes.
And what is the expansive, my lord, 226, your lordship knows, my lord. Now, my lord, only one judgment prior to that is serial number 16, page 316, my lord. Where, my lord, the nomenclature, my lord, the Supreme Court came up and said, my lord, that the nomenclature, etc., my lord, is not required now.
Nomenclature, how is it relevant here? Nomenclature means?
Because they said, my lord, you have to go for quo warranto.
Oh, nomenclature of this relief.
Of the writ. So the Supreme Court came up and said, my lord, para 10 is important of this judgment of 1977, 1 SCC at serial number 16. It was quoted by, this is not a new judgment, it was quoted before the learned single judge, my lord. And my lord, at 322, my lord, para 10.
Yes, para 10.
In fact, had I known this judgment, I wouldn't have filed the, my lord, the amendment application. It could have been heard there. Sometimes the law, you know, keep on learning.
Keep on learning to the utmost for me, because this morning I delivered a judgment, dismissed a writ petition on the ground of locus standi, quoting Justice Krishna Iyer, who in turn quoted Benjamin Cardozo. I mean, judges are not knight errants going about doing benevolence and all these things at the behest of anybody.
I'll understand they look up to that.
Yes,
judgment.
they will look up to that.
Some
Anyway. So that's why becomes interesting,
yes,
casually, yes.
Every second,
Every
yes.
day, every second.
And when it comes from junior members, I feel very happy, my lord.
Everyone,
Something
yes,
will
that's
come back.
the charm of this profession. Either side, I mean, that is the charm of this profession.
I feel extremely happy. And but you even half my age, you comes up and say, I said, excellent, beta, well
Yes.
done. Now, my lord, para
It's
10.
not an exercise of brain only, of philosophy also, your outlook towards life.
Yes.
Every judgment, every matter,
True.
in a sense.
And every judgment will give you something new for the next round, my lord.
Right.
It always gives you.
Every interaction
Yes,
with the lawyers.
Yes.
Yes.
The mere circumstance, my lord, may I read that para 10?
Please.
The mere circumstance that the first respondent did not in so many words ask for the writ of quo warranto cannot justify the argument that the appointment was being challenged collaterally in a proceeding taken to challenge the award. Considering the averments in the writ petition, it seems to us clear that the main and real attack of the award was the ineligibility of Sri Gupta to occupy the post of a judge in the labor court. Here, my lord, he didn't have the eligibility to be a judge in the labor court, in the discharge of whose function the award was rendered by him. The writ of certiorari asked for by the writ petition was certainly inappropriate, but by clause C of paragraph 16, the High Court was invited to issue such other suitable writ, order, or directions as it deemed fit and proper. We always light it, and for any other such further directions. So this is the interpretation. As it deemed fit and proper in the circumstances of the case. Such other suitable writ, order, or direction. There is no magic in the use of the formula. The facts necessary for challenging Gupta's appointment are clearly stated in the writ petition and the challenge. I will not trouble you.
This is Justice YV, Father Chandrasekhar.
Yes, my lord. Yes. No, my lord. What is in fact certiorari, my lord? I'll trouble your lordship because that was also quoted in the approval, serial number 20. Starting from page 393.
Locus standi, yes.
Locus standi, my lord. And my lord, the relevant paragraphs possibly are missing because they are missing in my paper book also.
Yes.
My lord, 49 and 58, my lord. This again, my lord, to give some solace to myself, my lord, is by Justice Krishna Iyer.
Yes.
So, my lord, I'll read his judgment only, my lord.
Please don't do that.
There were, in fact, 7 judges, my lord, constituted. It's a very famous case, Bar Council of Maharashtra versus M.V. Dhabholkar, 1975 to SEC, starting at 393, my lord. And it, my lord, dealt with the phraseology, my lord, person aggrieved, as also, my lord, a writ of certiorari. So, person aggrieved was covered, and the paragraph I wish to rely, my lord, 49, I'll read for half a minute, my lord, and go immediately to my lord, 58. Paragraph 49, my lord, is at page 407.
Yes.
Back to the issue. Is the State Bar Council a person aggrieved? No narrow, pedantic, technical, or centenarian construction can be blindly applied. On the other hand, a spacious construction functionally informed by the social conscience and the salutary purpose of the enactment must illumine the judicial effort. So viewed, the ample import and breadth of meaning of the words person aggrieved will emplace the State Bar Council for reasons which I shall presently set out. And my lord, the reasons are each statute has a personality and a message. These paragraphs, your lord, if your lordship find the time, my lord, they give very good reading up to, my lord, para 58.
No, without looking into this, actually, Mr. Rahim, I'm going astray rather. I was just giving a speech. I mean, I think from my practice days, every act is like an Indian rag. When it has a spirit of its own. If you go through the index, I mean, you find the scheme of things.
Yes.
So it's like a rag roop sort of thing. You have to go into that. Once you go into that, you'll get the context of the entire act. Then you don't require to be aware of every provision. You get a feel of the provisions. I mean, it's exactly
reading the
here it says personality.
Yes, personality.
Right.
In fact, my lord, half a minute more, my learned friend will allow me. I was reading, my lord, Irving Stone Michelangelo, my lord, the famous sculptor.
Yes.
So, my lord, how he learned the art, my lord, he, my lord, used to quietly pay somebody, my lord, and enter into a morgue. And in the morgue, my lord, there were bodies, my lord. He used to dissect the bodies, and in the darkness, my lord, he used to feel them.
Yes.
And with that, my lord, his statues, my lord, they could. That is how.
Absolutely, it comes to you. It comes to you.
So that was the practice.
Like
just like your
meditation has various forms.
Yes.
It comes to you.
Yes.
Right. We were also told.
Yes.
There is a judgment, in fact, which says a plaint is like an animal. It has a head, a body, and a tail.
Yes, it has its own spirit. Absolutely.
Justice Amir Ali.
Oh, that's right. I didn't know that. I didn't know that.
Sanjeev Banerjee once.
Who else?
Being severely critical of my plaint,
See, your plaint was a real animal. Like.
No, but this is before his lordship, my lord, was elevated.
Elevated,
So,
yes.
my lord, the plane naturally went into the dustbin.
Yes,
But
obviously.
This is what he told me.
Yes.
In fact, one of the first plaints I read, Milord, Mr. Abhijit Mitra's father, Milord, 2.5 pages, Milord, on spec. 2.5 pages.
Yes, absolutely.
1969 or 70.
See the Privy Council judgments and today's judgments. Hundreds and thousands of pages of judgments today. I mean, they are also good.
Yes.
But anyway.
I must, include this. Yesterday, 2 days back, somebody was reading a book on law at the bar library. I was flipping through it. There's a picture of the prayers made in the Keshavnan Bharati petition. Short 2 prayers. Declaration that such and such is ultra virus, unconstitutional.
What else is required actually?
No effect be given to it.
Right.
And I was telling my friends that if I had to draft this petition, minimum of 8 prayers. Mandamus, no effect. Sashirarai, this prohibition, don't give effect.
Absolutely.
No, so these other
Yes.
paragraphs your lordship can read, Milord, but
Yes.
at paragraph 58 begins at page 410.
Yes.
And Milord, I'll trouble your lordship, Milord, at paragraph 59, page 411, which has been quoted in the judgment on 14th of June. About 10, 12, 15 lines from the bottom, Professor H.W.R. Wade has observed. Now, with respect to certiorari. In other words, certiorari is not confined by a narrow conception of locus standi. So what was, Milord, quo volunto required, a locus standi?
Yes.
But here, Milord, in other words, certiorari is not confined by a narrow conception of locus standi. It contains an element of actio popularis. This is because it looks beyond the personal rights of the applicant. It is designed to keep the machinery of justice in proper working order by preventing inferior tribunals and public authorities from abusing their power, etc. And then again, my lord, because it was argued, the possible apprehension that widening legal standing with a public connotation may unloose a flood of litigation which may overwhelm the judges is misplaced, because a public resort to court to suppress public mischief is a tribute to the justice system. In this very case, to grant an exclusionary windfall on the respondents will cripple the Bar Council in its, and importantly, my lord, search for justice and insistence on standards.
But this approach in those days have led to so many pendency of cases.
What can I say?
And the pre-puja bonuses of our court. Those have led to the present pendency.
Sometimes, my lord, there is...
Justice Sanjeev Banerjee had been telling me once, I mean, in a different context, that in any civilized legal framework,
Yes.
nowadays the rejection is much more. Percentage of rejection dismissal at the outset is much more than allowing those, entertaining. Because of these reasons, balancing conflicting considerations.
But it's always very difficult for a judge to, my lord, at the inception, my lord,
Yes,
to balance
ultimately, yes, you have to balance that.
Yes.
That's your job.
Your lordship's, my lord, experience is much, much more.
No, not that. Very well. So,
how it has been dealt with by the eligibility criteria are 2 judgments, 3 judgments, 17, 18, 19. At serial number, I'll read 1 paragraph of that only and not take more than 5
continue after 2.
Greatly obliged.
Come
Much
back after 2.
Yesterday, my lord asked us to come back, come at 1 p.m. today.
Yes.
Where if in
No, no, we are 10 minutes. No, no.
Last day before vacation.
My lord has indulged.
Yes. What can be done? You have appointed somebody who is you are that appointee.
I am the appointee.
You have been appointed by the state.
But I was
Aggrieved.
But I was just
No,
mentioning.
Mr. Chakraborty, yes.
But I was just mentioning item number 18 to 25, upgraded motion. My lord allowed me. If my lord want, I can come back after vacation. If it can be there in the list in the same.
You're for the petitioner.
I'm for the petitioner.
You had mentioned on the ground of urgency.
Yes, man.
18 to 25.
18 to 25.
Thank you,
On
Mr.
the
Chakraborty.
reopening day, my lord.
Please ask your learned junior to inform the other side. I'm just relaying.
I'm informing immediately. Mr.
Immediately.
Kundulia is appearing.
18 to 25.
18 to 25.
After vacation.
On the reopening
Not
day,
this week. It will remain.
it will automatically come on it.
I'm making not this week only.
My lord. Deeply obliged.
18 to 25.
Deeply obliged.
So you have to fill up those places.
I am resigned to my seat. I should be back at 2 o'clock.
So have I.
3:30, my lord. So I'll not.
Yes. Mr. Rahim, I'll give you 5 more minutes. You'll have to complete all your paragraphs. Irrespective of what your learned junior is saying. You'll have to complete it in 5 minutes.
20 minutes বলেছিল 1.5 ঘন্টা বলেছে
Yes.
Yes. In similar circumstances, my lord, there are two judgments, my lord. At serial number, my lord, 17, eligibility criteria, my lord. Yes. Mir Safiullah. My lord, I just read para 7, 10, and 11. If your lordship kindly make a note. That 11 is missing. 7, 10, and 11, my lord. Yes. 7, my lord, begins at 337. Here, my lord, it was 14(1)(d), through and through, my lord. The writ petition was filed, my lord. Yes. Lord, I don't want to trouble your lordship with the beginning of the paragraph. Right. 336, my lord. Yes. Middle of the page, line beginning, my lord. No reports were called. No reports were called from the concerned authority, and no other inquiries were made to ascertain whether the members whose names were recommended satisfied the criteria laid down in clauses C and D. The power thus exercised in casual manner and a bald recommendation unsubstantiated by any material. Now, my lord, the court, my lord, in its wisdom, my lord, thought that instead of, my lord, remanding the matter back, my lord, they decided the issue in this matter, my lord. Page 337, middle of the page, line beginning, but. Yes. But on account of long passage of time from the date of appointment, we are not inclined to adopt that course. And then, my lord, they saw the credentials. Last 4 lines, same page. If there is no material before the court which could induce a reasonable body of person to reach the satisfaction as regards the fulfillment of the criteria laid down so and so, or if a reasonable doubt is created as regards the reliability of such material, the appropriate course would be to set aside the appointment. The jurisdiction vested in the court under 226 is discretion and meant to advance the cause of justice. Now, my lord, para 7, my lord, I don't want to trouble your lordship. It's a very lengthy paragraph. My lord, I'll go straight to para 10, my lord. Page 344. Yes. Because this is the meat of the matter. Here again, my lord, there were Sunni theologists, my lord, and Shia theologists. So the criteria, my lord, for Sunni, my lord, were discarded, and evaluating the basis, my lord, the articles, the books, etc., my lord, the full list is there. The Shia was, my lord, appointed. Now, my lord, then we come to the cases of respondent 5 and 6 who are nominated in the clause D. So D as a scholar in Islamic Sunni, and then, my lord, about 7 lines down the page. However, even on the basis of the very material furnished by 5th respondent, it is difficult to reach the conclusion that he is a qualified in Islamic theology and a recognized scholar. So he was leading the prayers, etc. It wasn't like this a Mutawalli. He had, my lord, something to his forte. But, my lord, the court found, my lord, that the theology part of it, my lord, and the recognition as scholar is missing. He filed certificates, etc. All they say he is also Khatib and chief of the Arabic school. All these things are there. Now, my lord, what is actually theology? The court, my lord, noted, page 345, just about 10 lines from the bottom, my lord. Yes. It is noted that your lordship has been systemized into a science. Under this head, the following subjects, and there's all this: commentary on Quran, pertaining to tradition, fundamental principles. The Madrasa board, my lord, has given. I'll read that one page only as what is to be studied. And, my lord, page 346, I'll skip over that. In fact, it says mere knowledge of Quran and familiarity with certain aspects of theology does not elevate him. Page 346, my lord. 8-10 lines from the bottom.
Mere outline knowledge.
Mere outline knowledge of Quran and familiarity with certain aspects does not elevate him. This is for the Sunni person. Now, for the Shia, my lord, the discussion starts at page 347, para 11. Then we shall take up the validity of nomination of Janab Sayyid Muhammad Yusha Fazi under clause D of such and such. A very well-known, my lord, person, lord. In the impugned order, it is mentioned that he is the head priest of Masjid Asghari, so and so. Now, my lord, just over the page, my lord, other qualifications are there, but I want to, my lord, highlight page 348.
Authored various books.
He claims to have authored various books and articles related to Islamic theology, which are of particular relevance to the Shia community. Some of the publications have been placed before the court at the time of hearing. He also produced a Maulvi certificate issued by the Arabic College at Banaras. The third respondent also furnished extracts in which articles is written about our Maulvi Sahab. So and so. He is Imam-e Juma Jamaat, chief priest of Masjid Asghari. The fact that he served as a high priest at Dar es Salaam in Africa and at Ranchi and Calcutta before he came to Bangalore in 1979 has been stated therein. His poetic talents, knowledge in Urdu, Persian, and Arabic, apart from English and Hindi, has been acknowledged therein. High compliments are paid to his humane qualities, especially his devotion to ethics and religion. A certificate dated so and so by the president of Mid-West Association of Shia organized Muslims has been filed. It states that he delivered brilliant and enlightening speeches on Islamic theology during his visits to Chicago. The third respondent submit that as the Maulana of Masjid so and so, he leads the prayers in Masjid. And then there was some allegation that his name came only because of the Janata Dal party that the court refutes, my lord. And says, my lord, at para 12, page 350. We are unable to hold on the material placed before this court that the third respondent in so and so cannot be treated as a recognized scholar. So they recognize and they don't recognize that mere qualification, little knowledge of the Sunni sect, my lord. Here it's a bit of a reverse. And my lord, this has been quoted with approval in the next judgment, my lord, which is at serial number 18. And my lord, I'll just read one paragraph of that, which is, my lord, para 25. Then, my lord, the recommendation, my lord, came from the chief minister. The chief minister, some names are given. He said so and so. So the mere recommendation, and the court came down heavily on such aspect of it. So this whimsically it can't be made, my lord. This political appointments can't be made in this manner, my lord. As in this case, my lord. Page 372, para 25. Shri so-and-so sent recommendation letter so-and-so to the Honorable Chief Minister, Government to nominate 5 persons named therein, which includes respondent number 5 and 6. The Honorable Chief Minister sent a note dated so-and-so, according approval for nomination of said person. This is the only material which I can find from the file. Neither any, I don't know if neither or neither again, my lord, neither any inquiry was made, nor any other report was called for with regard to possessing of qualification prescribed. So he in fact never went over there to show what was his credentials or come at the other point of time. Right. My lord, only 2 more pages, my lord. I'm so sorry, my lord. I'll take 2 more minutes. What is actually theology, my lord, and how it is taught in various things, my lord, because it may form part of the judgment, my lord. In the writ volume, my lord. I'm done with the judgment. Yes.
Oh, is a double. This copy was already handed over previously. Oh, দেখো সব মধা রয়েছে বলে এটা কাটো, মধাটা কাটো। ফেরত দাও। Please take this back, the previous compilation. Yes.
This was given earlier. My lord has got it.
All are here.
Yes.
Same thing, exactly same replica. So which page should I look
My
into?
lord, page 56, the avowment was there, my lord. Theology, etc., my lord, I say
Yes.
that Sunni was a Qari, my lord.
This was the previous repetition.
We filed a supplementary there, my lord. It's part of the records, my lord, of this court. Lord, so I say him, my lord, that theology, my lord, para 5.
No, I don't understand.
This was a supplementary affidavit, my lord, filed in the previous.
Previously, right? Yeah.
It wasn't filed, it was ready, my lord, but now it's part of the records.
Right.
Lord, para 5 at page 56, running page. What is actually theology, my lord? Say that it's a course which is taught for 3 years duration for BA and then MA, my lord, for being recognized. And then there are some advertisements. I say so again, my lord. Islamic theology has firstly to be an alim. Alim is, my lord, passing class 10. And then you become a fazil at class 12. Supplementary affidavit.
Supplementary.
Annexure P5.
Fazil is like class 12.
Fazil is class 12. Milord, to give relevance to Milord, to these amendments which I make here, Milord, there are certain annexures. There is an Alia University, Milord, which teaches the course, Milord. The relevant pages are, Milord, 69, 70, and 73 run of the same paper. So this has to be read with, Milord, page 69, 70, and, Milord, 73. And where they say, Milord, theology, etc., Alim, Fazil, what all is the requirement, the basic requirement
of this writ petition?
No, we are trying to trace out
No, it's a running.
Basically,
supplementary.
the present writ petition.
No, supplementary affidavit.
No, not here. In the earlier round.
That was a supplementary affidavit in the previous writ, which is an annexure to the present writ.
Oh, that's
These are
why
the
I
page
couldn't
numbers of
find the
this.
supplementary
I understand that.
No, Milord,
These are the course details.
these are the course Alia University, Milord. 69, it says 3 years at the bottom of the page. 69, Department of Islamic Theology. Candidates must have passed with at least 45 right-hand corner, Milord.
Yes, yes.
Eligibility.
What is the qualification of this person, as according to you?
I think he's not a graduate.
What is your, I mean, who are you? You are a member of the Shia community in
We
general.
are, Milord, members of the Shia community, Milord.
You are a group.
We are a group, Milord. We say so in our representation. We are 5 members in the representation. We are Shia members. All 5. And the first one, in fact, Milord, he was the Milord, he was the president of the Bongobashi College, Milord. He was the principal.
This person?
The first petitioner.
First petitioner.
He was very learned man, Milord. Very learned man. A lot of people know him. There are a number of students, Milord, in the corridors of this court, Milord, who know him. So he also couldn't apply because it happened behind closed doors. So, Milord, the 3-year course, your Lordship has it, Milord. And 45, the last column, page 69, and the first column, page 70. For the 2-year MA course, Milord. Apart from, Milord, the further requirement which I say of recognition. And then, Milord, by page 73, clause 6.1, qualifying examination for UG. So there has to be final examination of 10+2 system conducted by any recognized central board, etc., with the madrasa education. So this is a private university, but, Milord, what the madrasa education board says, Milord, page 78.
Yes.
Milord, 78, Milord, should be read with 21 because it is the same ministry. The Ministry of Minority Affairs and Madrasa, the one which issued the notification, the 28th January notification, is the one which gives this qualification also. It's the same. Senior Madrasa Education System. The notice, the publication, 28th January, page 21. Ministry, Minority Affairs and Madrasa.
Yes, yes.
So it's the same. So they know.
Yes.
What should be the qualification? They would be the best persons.
Yes.
Is their prescription. And, Milord, only one paragraph, and I will not trouble your Lordship anymore. Milord, page 78. This education system is a bit fine print, Milord. This education system is a balanced blend of moral teaching, learning.
So this is on their website or what?
Yes, I believe so. It's on the website. Online student.
Board of Madrasa. This is the Board of Madrasa Education.
West Bengal, top left corner.
Yes, new online student registration now. Right, very well.
Yes. This education system is a balanced blend of modern teaching, learning, theology, and Islamic culture with modern education, science, so and so of the review community. Third line, Milord. The curriculum and syllabus from primary to postgraduate have been restructured with a view to open access to higher education, employment, possibility, and social opportunity. The senior madrasas running from classes 1 to class 10 are called Alim Madrasa. That's where you get the word Alim and Fazil.
Yes, Alim.
And the madrasas from 1 to 12 are called Fazil Madrasa. In addition to language, social science, science subject, Bengali, Urdu, English, so and so, and subjects like Arabic, Islamic, now theology. Then there is a bracket, Milord. After theology, second last line, subjects like Arabic, Islamic, if your Lordship have I read too fast?
No, this is the first paragraph itself.
First paragraph, the
theology,
the
yes.
Third theology, and then the brackets is there.
I don't find. Oh, achha, yes, yes, sorry.
Hadith, tafsir, and fiqh. These are, Milord, very specialized branches of theology. Hadith,
what are hadith, tafsir, and fiqh?
Hadith, Milord.
These are literature.
Hadith, Milord, are, Milord, what the Prophet, Milord, My lord, he, my lord, and his progeny, my lord, for Shia, my lord, we follow the lineage of the Prophet, my lord.
Yes.
They, my lord, revealed or my lord spoke about. So there are number of books on hadith.
So it has boiled down to literature, some sort of.
It is boiled down to literature, my lord.
All these three.
All this is fiqh, my lord, is Islamic jurisprudence.
All right.
Like my lord, shares what a sister or
Yes, yes,
all those is fiqh. And
Is a paragraph such, that's how you quote it.
they have been quoted, my lord. Justice Nariman has quoted in.
It's in paragraphs. So, my lord, when you quote it, it's, my lord, the whole thing is now codified in paragraphs.
Oh.
And the interpretation of that, my lord, are subject matter of various religious discourses.
Obviously, yes.
They would be. And tafsir, my lord, must be some details. My lord, I am neither an alim nor a fasid, my lord. So, my lord, and this is my respectful submission, that he does not meet any of the criteria, my lord. It was a pick and choose policy behind closed doors, my lord. Totally whimsical, my lord. Nobody was called when he was called, and he's an FIR name, making him, my lord, a Nazir or etc., my lord, when there are FIRs pending, my lord, something very, very serious.
Yes.
That Mr. Siddiqui wants to address first.
I think that will be, that looks proper.
Yes.
Instead of you defending yourself first, the
Yes.
state defending the decision.
No, my lord, now the question is, who can get rid of this obligation today? Normally, I am the last person to insist.
Well, I have to rush.
No, Mr. Siddiqui is very fast.
I have appointed him. My appointment is under.
Absolutely.
Let me tell your lordship the real reason he is not there tomorrow. I can still manage to come.
Yes, Mr.
My lord, not a docket. I don't come back. My lord, I think that I have possible. My lord,
But don't become a pain in the neck. Just better come here. Literally, you'll become a pain in the neck after a few minutes.
no.
If you have to, no, come here. Come to the center.
You have the table, no? The table.
There is some propriety to court proceedings also.
Sorry.
Yes, Mr.
But what has been challenged or assailed in this writ petition is a reasoned order which has been passed by the Minority Secretary of the Minority Affairs and Madrasa Education Department, and which has been passed as a sequel in compliance of the order of this honorable court. Now, my learned friend started his argument by saying that initially when this writ petition was taken up for consideration, there was an order of this honorable court where the state was not represented. Wherein the state, in this writ petition, wherein the state was asked to disclose as to what was the selection procedure and who were the persons who were taken into consideration for subject to correction, my learned friend. My lord,
yes.
My lord, and who were the persons concerned who were taken into consideration, amongst whom this particular person, the respondent number 2, was selected.
Right.
So that is the contention. Now, thereafter, the state was represented through me, my lord, in this matter. We filed an affidavit in opposition specifically stating that this is a nominated post. It does not entail any adverse civil consequences since it is a non-remunerative post. So I have taken recourse to doctrine of pleasure. I have seen that this person can fit in under section 14 subsection 1 clause D of the Waqf Act. Now, my lord, the second question which comes into consideration and which is very vital for effective adjudication of this list is with regard to whether this person can be considered as a recognized scholar in Islamic theology. That is the expression used in the provision, whether he is a recognized scholar or not. And for that, my lord, my learned friend has relied upon numerous judgments with regard to, and he has also relied upon Alia University's brochure and Madrasa Board's brochure, and with regard to Alim and Fazil. Lord, before entering into, my lord, this fact, because my learned friend was, my lord, with my letting understanding of Mohammedan law, my lord, Alim, Fazil, my lord, these are the words used, my lord, these are the words to connote a person who has ilm.
Who has?
Ilm.
Knowledge.
Knowledge.
Ilm, yes.
From the word ilm, the word alim has been derived, my lord. A person who has a knowledge, who has ilm, becomes an alim.
Right.
Now, my lord, this alim has a very wide connotation. The alim which is given to the board of madrasa education or through the alim university, which is now a separate autonomous body, my lord, these alims cannot be, my lord, considered to be the same of those alims who are also coming from the top madrasas of this country. But I'm talking about, there are alims who give sermon. There are alims, my lord, who preach or propagate the religion.
So
There
to
are,
be an alim, it is not dependent on the course curriculum of a particular.
it is dependent, my lord, because these alims, my lord, are different types of alim. Because your lordship has seen, my lord, in this honorable court, many matters of madrasa board comes up, and the courses are referred to as alim. Class 10 pass alim, class 12 pass fazil.
Yes.
But those alims cannot be equated with the alims which were referred by my learned friend in the judgment of Karnataka High Court.
All right.
Those alims come from a renowned university. In the case of Shia, subject to correction, there is one Jamia Shirazi in Lucknow. From those universities, from those schools, my lord, they are coming. These are all 10 years courses. And they devote their entire life for such courses.
So their entire life comprises of 10 years only.
10 years for alim, 2 years for fiqh, further 2 years for mufti.
So that's like the course curriculum. This is also 10 years.
10 years.
So what is the difference between the two?
This is a huge
Maybe coming from a renowned university, but it's all the same then.
No. My lord, in this case, West Bengal Board of Madrasa Education, subject to correction, my lord.
Yes.
West Bengal Board of Madrasa Education, the course curriculum or the syllabus comprises of English, maths, and
something
all
else
those,
also.
and Muslim, my lord, English, Muslim scriptures and everything. But in those courses, my lord, these who are coming from these universities,
This is specialized on Islamic theology.
They come from, my lord, Deobandi school is there in the case of Deobandi. In the case of Shia, there is Deobandi school, there is Barelvi school, there is Nadwa.
That's a school of theology.
School of theology, my lord. This is
Yes.
basically school of theology.
Maybe,
So
yes.
it is because my contention before your lordship, I just want to distinguish, because your lordship will be under the, my lord, impression that he has to be an alim or a fazil. My lord, my contention before your lordship is that
a fazil under the curriculum cannot be a Islamic theologist. Definitely not. Class 12.
Class 12. Fazil is not.
Cannot be.
But the fazil, the same honorary degrees given to those persons who are coming from those schools. It becomes fazil. Then there are muftis.
In the case of this private respondent, is he any of them?
No, he is not. None of them.
Very.
My contention before your lordship, my lordship kindly cannot. My lordship may kindly do not enter into this that arena, because I want to demonstrate before your lordship with my limited understanding of Mohammedan law that the job which a member of the board is to perform is not something ecclesiastical.
Yes.
Well, Lord, the board of Waqf is ordained with the duty to manage and administer all the properties, all the Waqf properties in the state of West Bengal. Manage and administer all the Waqf properties, nothing beyond that. So there are Shia Waqf properties, Shia Waqf state, and there are Sunni Waqf state. So this is being managed by the board of Waqf. Now, the question arises whether to be a member of the board of Waqf and to manage and administer those properties, whether I should have extra knowledge about Hadith, about Quran.
But Mr. Siddiqui, still the statute says under 14B that you have to be a recognized scholar of Islamic theology. Nothing less than that. Recognized scholar of Islamic theology, not only Islamic law.
But it does not specify, my lord, who is to be a recognized scholar specific Islamic theology.
No.
My lord, I may consider to be much better than any recognized scholar in Islamic theology.
You may be much better than me. You may be much better than me.
No, Islamic
theology.
At least Islamic.
I mean, not a recognized scholar.
My lord, if at least Islam is concerned, my lord, if my understanding of
Islamic theology is of a higher pedestal.
Higher pedestal, my lord. Because my lord, it
cannot be mere administration of an estate. Islamic theology is not
No, it's not
confined to that.
mere
But
administration.
that is required under the statute. That is what
The
the
statute says, my lord, I have a judgment with regard to that, and my lord, the High Court has said, my lord, Islamic theology, my lord, is something like, my lord, my understanding of my religion. It is my relationship with the Almighty. And I understanding the tenets of my religion.
theology is that.
Theology, if your lordship kindly appreciates, the theology is my reading of a particular religion, Islamic theology, Islamic religion, my lord, my reading of that religion. And this person, according
There are no uniform standards of theology in a particular religion.
So there are no uniform standards. There cannot be any uniform standards, subject to correction, my lord.
Very.
There cannot be any uniform standards.
It cannot be a science, as he was saying.
There cannot be a science. He was right. There cannot be a science.
He was not saying that. He was saying the contrary.
My lord, it cannot be defined, my lord. It cannot be kept in a definitive mode that this is the criteria under which you can become a person who is a religious scholar, Islamic theology. Now, my lord, this is just the outline of what I'm going to submit before your lordship. Now, my lord, at the outset, before my learned friend proceeded in the matter, I submitted before your lordship that initially when the writ petition was taken up, both me and the private respondent, raised the maintainability point that the writ of mandamus cannot be maintained by him because he has no right over the post. So I relied upon that, my lord. Subsequently, during the pendency of the writ petition, he came up with an application and the writ of quo warranto, and his locus has now widened. Because if the writ of quo warranto is, but still, my lord, it has to be decided whether the person concerned is holding a public post or not. Because the sine qua non for issuance of a writ of quo warranto, my lord, subject to correction by my lord, is that the post concerned is a public post, and that the person concerned who is holding the public post is a usurper.
Right.
It has to be a public post, and the person has to be a usurper. Now, my lord, in my little understanding of the Waqf Act, he is a member of the board. He is one of the member of the board amongst so many members.
Yes.
So, he individually cannot take any decision. He is not holding any remunerative post. His is a nominated post. He only attends the board whenever the meeting is called for with regard to any Waqf state. He does not have any office in the board. So, my lord, the post which he is holding cannot be equated to be a public post.
Very.
So, when the first criteria with regard to that post, my lord, goes, the entire edifice goes. Because if it is not a public post, then he cannot be a usurper.
Very. What else, Mr. Siddiqui?
Without beating about the bush, my lord, I'll just come directly to the judgments, my lord, which I'm relying upon.
Yes.
And my learned friend, my lord, I had relied upon it, upon those judgments earlier also.
Yes.
So, my lord, he knows about it. My lord, first in the queue is 2011 SCC Online Cal 603.
You are reciting his judgments.
My lord.
No, I have that bunch.
But still, my lord, your lordship have to search for it.
What is the
2011 SCC Online Calcutta 603. This is my judgment, my lord. I had relied upon it, and it may be
not his judgment, not
his.
Oh, achha. Yes.
I had earlier relied upon this judgment.
Achha, very. Yes.
Well, this is the judgment, my lord. In fact, since it has come through SCC Online, so the paragraph numbers are not there. Your lordship may see that. Paragraph numbers are not there. My lord, I am placing reliance upon, my lord, the last of the paragraph in the first page.
Right.
Before considering the legality of such appointment of the members in the work board, this court wants to consider the locus of the petitioner to maintain this writ petition.
This was of the Port Blair bench.
Port Blair bench, my lord.
Tabriz was appearing. That's right. And Lieutenant Governor. Yes. Right.
Senior advocate one.
Yes, I know him.
My lord.
Yes.
The petitioner has not stated in the writ petition that he was aspirant for appointment as a member of the said board from any of the categories as mentioned in section 14 of the Waqf Act 1995. My lord, this, my lord, the petitioner has not stated in the writ petition that he was aspirant for appointment as a member of the said board from any of the categories as mentioned in section 14 of the Waqf Act 1995. The petitioner has also not claimed that though he had the right to be considered for such appointment as a member of the said board, but he was ignored. He simply stated in the writ petition that he has a right to maintain the writ petition as he represents an eminent Muslim organization. In my considered view, this solitary statement made by the petitioner in the writ petition is not sufficient enough to establish his locus to maintain the writ petition unless the petitioner establishes that he was aspirant for such appointment and he was not considered though he was an eligible candidate for such appointment. His right to challenge the legality of appointment of the members in the work board cannot be held to have matured, particularly when this writ petition was not filed in the nature of public interest litigation. Thus, this court holds that the petitioner has failed to establish his locus to maintain the writ petition. Thereafter, the court went on to discuss with regard to the merit also, and on merit also this matter was dismissed, my lord. I'll not trouble your lordship further. Second is with regard to that the petitioners cannot be termed as an aggrieved person in order to have locus standi. With regard to that, I am placing reliance upon 2013 volume 4 Supreme Court cases, page 465. My learned friend has placed reliance upon many judgments which were of 1965-66 that this court's power is immense. There is no res integra to that, my lord, that this court's power is immense. But, my lord, we have been taught, my lord, subject to correction, that whenever we file a writ petition, the first and foremost thing we have to demonstrate before your lordship that I am an aggrieved person, I have the locus to file a writ petition, and the person against whom I am approaching your lordship is a state within the meaning of Article 12 of the Constitution of India. Now, my lord, with regard to aggrieved person, if your lordship kindly turns to paragraph 9 of this judgment.
Was this a quo warranto case as well?
No, quo warranto I'll come later.
This was not a quo warranto.
This is with regard to persons aggrieved. I'm still into mandamus, my lord.
Very good. Which paragraph?
Paragraph 9, my lord, at page 475 at the bottom.
Citation? Yes.
Citation is 2013, volume 4, Supreme Court cases, page 465. Paragraph 9. It is settled, person aggrieved. It has been titled as person aggrieved. It is a settled legal proposition that a stranger cannot be permitted to meddle in any proceeding unless he satisfies the authority court that he falls within the category of aggrieved persons. Only a person who has suffered or suffers from legal injury can challenge the act, action, order, etc. in a court of law. A writ petition under Article 226 of the Constitution is maintainable either for the purpose of enforcing a statutory or legal right, or where there is a complaint by the appellant that there has been a breach of statutory duty on the part of the authorities. Therefore, there must be a judicially enforceable right available for enforcement on the basis of which writ jurisdiction is resorted to. The court can, of course, enforce the performance of a statutory duty by a public body using its jurisdiction at the behest of a person, provided that such person satisfies the court that he has a legal right to insist on such performance. The existence of such right is a condition precedent for invoking the jurisdiction of the courts. It is implicit in the exercise of such extraordinary jurisdiction that the relief paid for must be one to enforce a legal right. In fact, the existence of such right is the foundation of the exercise of the said jurisdiction by the court. The legal right that can be enforced must ordinarily be the right of the appellant himself, who complains of infraction of such rights and approaches the court for relief as regards, and certain judgments of the Supreme Court has been quoted. Thereafter, paragraph 13 at the next page, my lord, page 477.
Yes.
This court, even as regards the filing of a habeas corpus petition, has explained that the expression next friend means a person who is not a total stranger. Such a petition cannot be filed by one who is a complete stranger to the person who is in alleged illegal custody. Then, my lord, paragraph 17. This is the, my lord, with regard to, in view of the above, the law on the set point can be summarized to the effect that a person who raises a grievance must show how he has suffered legal injury. Generally, a stranger having no right whatsoever to any post or property cannot be permitted to intervene in the affairs of the others. Then, my lord, paragraph 23, locus standi. This is with regard to locus standi. This is the concluding paragraph with regard to locus standi. Thus, from the above, it is evident that under ordinary circumstances, a third person having no concern with the case at hand cannot claim to have any locus standi to raise any grievance whatsoever. However, in exceptional circumstances as referred to above, if the actual persons aggrieved because of ignorance, illiteracy, inarticulation, or poverty are unable to approach the court, and a person who has no personal agenda or object in relation to which he can grind his own axe approaches the court, then the court may examine the issue, and in exceptional circumstances, even if his bona fides are doubted, but the issue raised by him, in the opinion of the court, requires consideration, the court may proceed suo motu in such respect. Now, my lord, with regard to quo warranto, but I am placing reliance upon 2000, Volume 2, Supreme Court Cases, page 699. Paragraph 6, my lord. It's an elaborate paragraph. My lord, this is, my lord, I'll tell you with regard to this, because initially when the writ petition was being heard, my lord, Justice Bhattacharya, my lord, my learned friend was subject to correction by him. My lord relied upon Section 101 of the Waqf Act. But today it was not submitted before election. So by taking cue from Section 101, that these officers of the Board of Waqf are deemed to be a public servant. Since he is a public servant, therefore the office which he holds is a public office. Because my notes is also in that same line, my lord. That is why I'm placing lines upon this judgment. I do not know whether it will be relevant at the present, because he has not submitted before your lordship with regard to Section 101. Because Section 101 of the Waqf Act states, my lord, these persons are deemed to be a public servant. And if your lordship 101, my lord? Yes. Subsection 2. Every mutawalli of a waqf, every member of a managing committee, whether constituted by the board or any deed of, no, subsection 1, my lord, I'm sorry, my lord. The survey commissioner, members of the board, every officer, every auditor of the board, and every other person duly appointed to discharge any duties imposed on him by this act or any rule or order made thereunder shall be deemed to be a public servant within the meaning of Section 21 of the Indian Penal Code. But I don't think it is not
slightly on a different foot.
It is not relevant, because my learned friend has rightly, in my respectful submission, has not pressed upon it today. So this judgment your lordship may kindly ignore, because my notes is because in my notes I have referred to this judgment. Your lordship may kindly ignore this judgment at the present moment, because
What does this judgment hold?
With regard to deeming fiction, my lord, are deemed to be a public servant, my lord, with regard to deeming fiction. Next is specifically with regard to quo warranto, that is AIR 1965, Supreme Court 491. Yeah, okay. 1965.
Yes.
But I am placing reliance upon paragraph 6 and 7 thereof.
Yes.
The judgment of the High Court, has your lordship got that? Paragraph 6.
Yes.
Well, the judgment of the...
I'm sorry.
I'm sorry.
Pages are very fragile.
These are old books, my lord.
The judgment of the High Court, yes.
The judgment of the High Court does not indicate that the attention of the High Court was drawn to the technical nature of the writ of quo warranto, which was claimed by the respondent in the present proceedings, and the conditions which had to be satisfied before a writ could issue in such proceedings. Paragraph 7, my lord. As Hasbury has observed, an information in the nature of a quo warranto took the place of the obsolete writ of quo warranto, which lay against a person who claimed or usurped an office, franchise, or liberty, to inquire by what authority he supported his claim, in order that the right to the office of franchisee must be determined. Broadly stated, the quo warranto proceeding affords a judicial inquiry in which any person holding an independent substantive public office independent substantive public office or franchisee or liberty is called upon to show by what right he holds the said office, franchisee or liberty. If the inquiry leads to the finding that the holder of the office has no valid title to it, the issue of the writ of quo warranto osts him from that office. In other words, the procedure of quo warranto confers jurisdiction and authority on the judiciary to control executive action in the matter of making appointments to public offices against the relevant statutory provision. It also protects a citizen from being deprived of public office to which he may have a right. It would thus be seen that if these proceedings are adopted subject to the conditions recognized in that behalf, they tend to protect the public from usurpers of public office. In some cases, persons not entitled to public office may be allowed to occupy them and to continue to hold them as a result of the connivance of the executive or with its active help. And in such cases, if the jurisdiction of the courts to issue writ of quo warranto is properly invoked, the usurper can be ousted and the person entitled to the post allowed to occupy it. It is thus clear that before a citizen can claim a writ of quo warranto, he must satisfy the code inter alia that the office in question is a public office and is held by a usurper without legal authority, and that necessarily leads to the inquiry as to whether the appointment of the said alleged usurper has been made in accordance with law or not. But in my
It's part of the compilation.
well, in my limited understanding, well, the petitioners have miserably. It was there. That is why I brought that book, because it was there in the compilation.
Serial number 13.
13.
Thank you.
But I tender my apology because it was already there in the.
No, sir.
I relied on
But in my limited, my lord, but the petitioners have miserably failed to demonstrate, my lord, that the post in question is a public post. Now, my lord, coming to the merit of the writ petition. I will not detain your lordship further with regard to that Islamic theology and everything, my lord. I have written there in my notes. But, my lord, in support of that,
this note,
my lord, it is starting from page 7 and 8, my lord. I have written with regard to the merit that what is the all this theology is to be decided. Who is a scholar? Who is a recognized scholar?
Yes.
These are all very vague terms. My lord, now, my lord, I am placing reliance upon this Uttarakhand High Court single bench's judgment, my lord, 2021 SCC online, Uttarakhand 1185.
Yes.
I'm placing reliance upon paragraphs 4, 6, 9, and then 13 to 17. Now, paragraph 4 is in the third running page.
Yes, please. Yes. Got it.
Respondent, my lord, may I place it, my lord? Respondent numbers 3 and 4 have been appointed under section 14(1)(b)(1) of the Act. It is the contention of the petitioner that only present ex-member of parliament can be appointed under said provision. Since respondent numbers 3 and 4 have never been members of parliament, therefore their appointment under section 14(1)(b)(1) of the Act is bad. Regarding respondent number 5, petitioner contends that neither he is a recognized social worker nor he has the professional qualification, professional experience of social work. Therefore, he is not qualified to be appointed under section 14(1)(c) of the Act. Petitioner has questioned appointment of respondent number 6 on the ground that he is not a recognized scholar in Shia or Sunni Islamic theology. Now, thereafter, paragraph 6. The challenge thrown by the petitioner to appointment of respondent number 4 is unsustainable in the eyes of law. In view of the provision contained in section 14 subsection 3 of the Act, which provides that where the state government is satisfied for reasons to be recorded in writing that it is not reasonably practicable to constitute an electoral college for any of the categories mentioned in subclauses 1 to 3 of clauses B of subsection 1, the state government may nominate such person as member of the board as it deems fit. Regarding appointment of respondent number 5, learned counsel for the petitioner, paragraph 9.
Yes, I understand.
Paragraph 9. Regarding appointment of respondent number 5, learned counsel for the petitioner submits that since respondent number 5 is neither a recognized social worker nor he is a member of NGO, registered society or trust, etc., and moreover, he has no professional qualification, experience of social work, therefore is not eligible for appointment under section 14(1)(c) of the said act. Now, paragraph 13, my lord. Regarding respondent number 6, it is the contention of learned counsel for the petitioner that she has knowledge of Urdu language only, but she is not a Molvi or Mufti. Therefore, she cannot be treated as a recognized scholar of Sunni Islamic theology. The challenge to nomination of respondent number 6 under section 14(1)(d) is also unsustainable for the simple reason that what is required is that one should be a recognized scholar in Shia or Sunni Islamic theology. There is no requirement that one should be an eminent or distinguished scholar in Shia or Sunni Islamic theology. The next paragraph. Learned counsel for the respondent number 6 submits that his client possesses Adib, Mahir, Adib, Kamil, Muallim, Urdu qualification from Jamia Urdu Aligarh, besides high school qualification from UP Board, Allahabad. He further submits that respondent number 6 that recognizes society for a knowledge regarding tenets of Islam. Learned counsel for the petitioner submits that respondent number 6 cannot be treated as a recognized scholar since there is no body or institution for recognizing a person as a scholar in Shia Sunni Islamic theology. Therefore, a recognized scholar would mean a person who has been recognized as such by the members of the community to which he belongs. Thus, it would not be an institutional recognition, but a recognition by the members of the society. The expression recognized has not been defined in the Waqf Act 1995. Therefore, in the absence of any objective yardstick for assessing the scholastic qualities of an individual, element of subjectivity would always be there. In such view of the matter, the subjective satisfaction of the great state government in treating respondent number 6 as a recognized scholar cannot be interfered with while exercising the power of judicial review.
Mr. Siddiqui, in this particular case, has anything else apart from that which has been quoted in the order, impugned order, any other qualification has been shown by you?
My lord,
or pleaded in your opposition?
No, we have
in your opposition. I'm not.
No, in my opposition, we have said, my lord, whatever is there in the impugned order, we have said that he is associated with all these Muslim.
Impugned order, I've seen. Yes, fair.
I cannot improve, but whatever is.
No, need not. There need not be necessarily an improvement. Subject that will be subject to what I hold at. So I'm just asking you whether there is anything else. Very.
They can, my lord, they can come up with if they have anything for the court. My lord.
Now after the appointment. Yes, Mr. Chaudhary.
But I'm just one more judgment, my lord. One more judgment.
Yes, yes. Yes.
My lord, this is 2006 SCC Online Daily 1405,
right.
Paragraph 12, 13, and 21. Well, I'll just take. I will literally take, my lord, 7 to 8 minutes. Not like that. Not like that. 20 minutes, my lord. I'm sorry.
That's a jive at you. 12, 13, and 21.
12, 13, and 21.
Right.
But paragraph 12 is in running page 3.
Yes.
According to the petitioner's counsel, the state government could nominate a person who is a recognized scholar in Islamic theology, provided he has some degree or formal education in Islamic theology. And since respondent number 4 does not have any formal education in Islamic theology, as such, he is not competent to be nominated under section 14(1)(d) of the Waqf Act 1995. Next paragraph, my lord. This has not been disputed that theology is the science treating of God, his nature and attributes, his relation to man and the universe. Consequently, Islamic theology will be the science of treating of Allah and his disciples and the nature and attributes and the relation to man and the universe. It will be the study of nature of God and religious truth and rational inquiry into religious questions. A recognized scholar for Islamic theology will not necessarily be a person who has formal education. Under section 14(1)(d) of the Waqf Act, the recognized scholar in Islamic theology cannot be construed to be a person having formal education or some other degree of certificates in Islamic theology. The learned counsel for the petitioner is unable to show as to how the words formal education or a person having formal degree can be read into the words recognized scholar in Islamic theology. Now, thereafter, paragraph 21, running page 5, my lord.
Yes. 21.
The inevitable inference in the facts and circumstances is that the nomination of respondent number 4 by the state government as a recognized scholar in Islamic theology is in consonance with section 14(1)(d) of the Waqf Act 1995, and the same cannot be faulted on the ground as has been raised by the petitioner. The respondent number 4 in facts and circumstances as has been contended by him will be a recognized scholar in Islamic theology, and there is no requirement that to be a recognized scholar in Islamic theology, one has to have formal degree from a school or a college in Islamic theology.
The most interesting part of this judgment is theology is the science treating of God.
Paragraph 15 may also be noted in this. Because how he got the degrees from his father, etc.
Yes.
The qualifications are there.
That you will deal with.
Right. Thanks.
But last but not the least, my lord, is the with regard to this doctrine of pleasure, my lord, when we invoke. This is 2018 SCC Online Cal 1141. It is also reported in 2018 Volume 2 Calcutta High Court Notes, page 33. My Lord Justice Banerjee, as Lordship then was sitting with my Lord.
That's
But I am just relying upon the two paragraphs in the penultimate page, paragraphs 23 and 27.
yes.
Just as in a matter of policy, courts are slow to entertain a challenge in a matter of choice of personnel for appointment to a public body. A constitutional court will not easily interfere with the choice. Though the submission of the state that such a matter is not justiciable cannot be accepted, it must also be said that a constitutional court would step in only when the choice appeared to be bad to the meanest mind, almost being on the verge of defeating the purposes of the appointment. If the legislation does not deem it necessary, Lordship may kindly mark that, my Lord, if the legislation does not deem it necessary to fix parameters for the selection, it would imply that an element of discretion is left to the executive. Unless such discretion is demonstrated to have been exercised in the most perverse manner that no reasonable person could have so done, the latitude given by the statute to the executive would not be curtailed by the court in fixing guidelines in such regard. Well, thereafter, my lord, paragraph 27, this writ petition was dismissed as no steps are warranted to be taken on the basis thereof, whether to interfere with the appointment of the second respondent in the first petition as a member of the commission of setting right the perceived lacuna in the said act of 2017, apparently not taking care of in the rules framed there. So these are my. Now I've literally taken 7 minutes.
Yes, thank you.
I'm grateful. May I take your lordship's leave, my land juniors?
দারুণ দিলে কিন্তু আমাকে ফাঁসিয়ে দিয়ে নিজে কালকে বেড়াতে চলে যায়।
Yes, Mr. Chaudhary, justify your nomination.
Next year, Milord.
How long will it take? I mean,
Milord, I have to argue. I'll be very quick, but it will take a little time. Kindly give me one. Lord, I'll start with, Lord, I'll come to the facts. On facts, my Lord, I'll endeavor to show that this is really a fight between persons, my Lord, involved with Waqf estates and persons who want to be involved with Waqf estates, who have made, my Lord, a committee called the Waqf Bachao Committee and are essentially intermeddlers. So, my Lord, it's with collateral motive and oblique intention that these petitions have been filed. Lord, I would request your Lordship, my Lord, with respect to my learned friend, to not take cognizance of these, my Lord, assertions that, my Lord, a burial ground is being converted into a shopping mall. It's not really there, and one has to see, my Lord, what is happening. On I'll restrict myself to affidavits, and I'll submit, my Lord, that what I find is that there are cross-criminal cases against each other. As is normally the case, my Lord, it's not for, my Lord, me to say who's right, who's wrong, but both are, my Lord, interested group of persons. His clients, my Lord, want my clients to be removed. My clients, my Lord, want to get out of it. There are also some personal, my Lord, vendetta involved. There are criminal cases, corporation complaints. All this is on affidavit, which I'll take your Lordship through. So, my Lord, it's not that a purely, a very pure philanthropic person is coming forward to save the world. It's a person with interest against a person who's also involved in Waqfs. Bunch of documents annexed to my affidavit to show that my client is totally, my Lord, involved with Waqfs, part of, my Lord, from the Wajid Ali Shah family. He's not part of many Waqf estates. He takes part in religious activities and is considered to be a scholar and somebody who's.
But Mr. Chaudhary, what are your credentials regarding
No,
this
nobody has
being a
credentials.
scholar in Islamic theology?
The Islamic theology.
Statute requires that.
It's as vague. The term, Islamic theology is as vague as it comes. There is, no qualification. There's one university. We checked up, Mr. Ali was also helping me. We found out Aliyah University, which is not very old. So, if I have to go by the logic that if you don't study from Aliyah University, you don't know Islamic theology, then, until the recent past, nobody knew Islamic theology. Secondly,
obviously that is not his argument. That is quite obvious.
That's the only example which is shown.
You understand what he's saying. The theology has a structure which is reflected. That is why you have an example he must have cited.
No, Milord. Theology does not have a structure.
If there is nothing called theology, Mr. Chaudhary, then why should it be there in the statute?
No, I'm not
Nobody
saying
challenged it.
I'm not saying there's no theology. There's no formal expression of education in theology.
All right.
There's a difference.
Very well.
We looked up, Milord, while preparing the affidavit. It's been some time.
Yes.
Aligarh Muslim University also has a degree. We look at that's what comes to your mind first. I looked at Jamia Millia.
Yes.
Didn't really find anything, but I remember having found Aligarh Muslim University, and I'm surprised my learned friend, who's very well versed in all this, hasn't annexed to that document. But the fact is that just because there are 2 universities or a handful of universities in India who now, in the recent times, gives you a class 10 and a class 12, and who also give you a BSc in theology, that doesn't mean that you have to be the BSc. That doesn't mean that you have to have that formal professional qualification. That's my argument. So, Islamic theology is something which doesn't come always with a formal qualification.
Yes.
The next question which I ask myself is, how do I, ascertain whether I am, well versed in theology or not? Theology is, religion. Religion is, primarily practiced at a mosque. And these, semi-religious activities which many of these Waqf estates partake. So, and this gentleman is a part of most of them. He's an important man in the Waqf world in Calcutta. All important Waqf estates and all important Waqf estates.
Mr. Chaudhary, isn't there a difference between the theological aspect of it, the theory aspect, and the application of it? I mean, in the mosques, what is going on in the mosques or in the temples or wherever?
Yes.
These are the applied aspect of the religion, but there's a theory behind it also.
Yes, there is
or
a
philosophy
theory
behind it.
There is a
Philosophy is all about that, not the applied portion of it.
Yes, but Maulavis,
yes,
are not graduates from any
need not be
university.
Need not be.
Also and it's not theology is not just restricted to Maulavis. There is no qualification. That's what
No,
I'm
but
trying
the moment
to.
you say you are a recognized scholar of Islamic theology,
Yes, please see
it
the
directly pertains to academics. One cannot be a scholar without an academic knowledge of anything.
So, once you are involved in these activities in a Waqf estate, etc., you also,
it has to be scholastic. You have to be a recognized scholar in economics.
I teach, I research, I speak about it, I go to Iran. So, these are, it's a situation, which it's not codified. There's no educational qualification. It's a question of perception based on cogent factors. And what are the cogent factors? That I'm involved in these activities in waqfs, in mosques. The section below is one person each from amongst Muslims to be nominated by the state government from recognized scholars in Shia and Sunni Islamic theology. He's challenged Shia. Now let's look at Sunni. What are his qualifications? Ask my learned friend to indicate.
He's a
that
Qari.
there's no Millard difference.
No, he's a
It's
Qari.
not that.
There's
I'm
no
sorry. I'm
difference.
so sorry. No, that's
Not that.
misleading the court, my lord.
So where is the professional qualification?
No. One person each from amongst Muslims to be nominated by the state government from recognized scholars in
Millard-
Shia and Sunni.
Correct. Millard. So
One scholar each, not what you are saying.
No, one scholar each. So that's why I'm saying
I'm
I'm
not
the
interested
Shia
in
scholar.
Sunni scholars.
No,
His only case is regarding Shia scholars. Why
Correct.
should
So
he-
Millard, let's look at Millard the Sunni scholar.
Why should you look into the Sunni scholars?
In the same
When a challenge is preferred, I'll definitely look into it.
Millard, the
Now
same
we are bothered with Shias.
same qualification Millard applies to the Sunni scholar also.
Yes.
He doesn't have Millard professional Mr. Siddiqui would show. He doesn't
What?
have Millard any formal qualification.
Who doesn't have?
Millard, my counterpart who is the Sunni scholar. He doesn't have.
Maybe two wrongs do not make a right.
No, I'm not saying two wrongs. I'm only looking at this, Millard.
No, Mr. Chaudhary, this is bad logic. So the Sunni person may not have qualification. When his appointment is challenged, we'll look into that.
Very well.
So let us confine ourselves to
Millard,
Shia.
I was looking at it from another Millard angle. If your lordship looks at the section, nominated by the state government from. Now, Millard, is the only criteria, recognized scholars. So these are the two words, scholars in Shia and Sunni Islamic theology. So you must be a recognized scholar of theology.
Islamic.
That's all. Or of Shia theology or Sunni.
Islamic theology, not Shia.
Islamic theology. So, this is extremely vague. It's as vague as it comes. There is no Millard qualification which is put.
Right.
Millard, the reason why I'm Millard stressing on this, that it's vague. It doesn't have, the statute does not have a criteria, educational or otherwise laid down, apart from using vague terms like Millard scholar and theology, is because this is left to the discretion of the state government. And the subject matter is such that if you were to select an engineer or a doctor, or a lawyer, there are recognized degrees. But here, there is no recognized degree. It's a question of perception.
Very good.
My learned friend till now, he said many things. But he has not said, what according to him is the recognized qualification. He's not said it once, because there is nothing to that extent. What he says is, you must be a class 10 or a class 12 using those terms. And you must be a graduate in theology from madrasa or this university. Where is it stated? How many are there? When did it start? Nothing like that.
Yes, cited certain judgments which enumerate certain criteria of those people there who were appointed.
I'll deal with
by way of a.
I'll deal with that. He cited paragraphs in respect. In fact, there's one very important judgment. He cited in respect. Point numbers 1 and 3 were removed, but 2 was not removed. Like he, looks at 1 and 3. I'll show your lordship 2. Now, before coming to that, the reason why I was arguing this is because suitability cannot be looked into or ought not to be looked into. Your lordships will not leave it. Section 14 is subjective satisfaction of the state. Integrity, caliber, and qualification cannot be judged because it's too vague.
What else, Mr. Chaudhary?
These are all cases which I have.
This argument I have understood. What else?
What else?
Perception vague, yes.
Yes.
What else are you prepared on today?
I've got, and then on the judgments on certiorari, quo warranto, Because there's a reason. My lord, he can't get in insofar as mandamus and Sashira are concerned. Let me show your lordship judgments.
Yes.
Kindly see, my lord,
Yes.
2013, 4 SCC.
Your respondent number, Mr. Chaudhary, 2.
Yes.
There's no prayer for mandamus, my lord. With respect, the prayers are limited to Sashurara and Kovaldo. There's no prayer for mandamus.
Correct. 2013.
This has been cited by the state also.
Yes, but there are two paragraphs which I will not show your lordship. Paragraph 9, my lord, first.
9 has been shown.
Then 10.
9, 10.
Your lordship has seen 9. I'll just take your lordship quickly to 10.
10 psychological and imaginary injury. Dealt with this morning only. And then Mr. Siddiq is cited. Now it is becoming
No,
adversarial.
no. If your lordship has read it, why will I not discuss?
9, 10. I'll note
Your
the
lordship has seen, my lord,
paragraph.
13, 4 SCC. Wiki dire, 611 dire. Oh, 13, 4, 611 SCC, 731. Paragraph 78. Lord, will I be very quick?
Yes.
Very well.
Para 78.
Hey, copy now. I'll give you. Just 1 second. You have an extra.
Give me the paragraph.
78, my lord.
78, I'm sorry.
Second line, certiorari jurisdiction can be exercised only at the instance of a person who is qualified to the post and who is a candidate for the post.
Yes.
Following, my lord, Umakant Saran, which is the parent judgment, sir, 1973, 1 SCC. And my lord, may I hand up?
Yes.
No. Look, I hate Supreme Court holidays. Look at the trouble I get into. Now, my lord.
Yes.
Next is, my lord. Now, citation. হয়ে গেল co-warranto, my lord.
Yes.
My lord, please see. No. আচ্ছা ঠিক আছে এখানে দেখেন. Please see, my lord, AIR 2005, Madras 111. My lord, this is exactly on, my lord,
Yes,
the
yes,
point. Section
exactly.
14 of the Waqf Act, constitutionality was
Right.
challenged. Now, my lord, please see paragraphs 5 and 6. দিচ্ছি, cool down. In that view of the matter, precise qualification, annual income, such and such would be a member who could not be a member. Secondly, 14(1)(c) and D. Nothing is defined. Who can be considered representative of eminent Muslim organization? 1(c) and D of the Waqf Act. It is clear that the part is selected representative from such and such given to the state government. Therefore, it is for the subjective satisfaction of the state government to consider the representative from the eminent Muslim organization.
Exactly what you said. Exactly what you said.
This is my idea to argue this point.
Yes,
Lord.
yes.
Now, my lord, next is all that the government should be aware is of the relevant criteria. And then your lordships leave it. My lord, just to take 1 minute, my lord, before I read the logic is this.
Yeah.
Mandamus, Sashurai, I am a person aggrieved. So when I come to fight for myself, your lordships, my lord, look at it in more detail. Because I am affected. The co-warranto is, my lord, public office. Anybody can come and say. So all that your lordships see is by what authority? Show me the legality of your appointment. The second something is shown, your lordships don't look at it further. Waiting, my lord, for the person aggrieved to come. Then your lordships go into it further. My lord, that I believe is the, my lord, logic behind these jurisdictions. And what, my lord, my learned friend said, a writ of or in the nature of mandamus, in the nature doesn't relax the criteria. Doesn't relax, my lord. None of his cases are on locus. Some other rigors, my lord, are given up, but never for once locus. Is it my learned friend's contention, I ask myself, that mandamus, my lord, he doesn't need to, my lord, satisfy the requirements? Can't be, my lord. Now, my lord, please see.
Which para?
My lord, I am showing your lordship. Andhra Pradesh, okay?
No,
My lord,
Rajesh Awasthi, which para?
my lord, I have showed Andhra Pradesh.
You cited this 2013 one.
Yes, my lord. I think I've given a wrong copy. This is, my lord, AIR 96, Andhra Pradesh, 187, para 15. Lord, please come straight to para 15. There is also appointment on the Waqf board. Although the writ petitioner has alleged that none of the appellants were qualified to be appointed to the Waqf board, section 11, no material was placed before the learned single judge or before us to support of their assertion. Government evidently wanted to show to the court all members of fulfillment. We inclined to think government sought complete information regarding biodata, etc., etc. Awareness as to eligibility for appointment is one thing, and keeping a statement containing biodata, etc., etc. of the government another thing. Then, my lord, when appointments of this nature are made, last two lines of the page, there is requirement that comparative merits of all available best person should be chosen, not possible by guidelines. My lord, then next page, my lord, fifth line, we may also take note of the fact that when appointments are made to bodies like the Waqf board, government naturally has to satisfy many sections amongst the classes, and no judicial is either permissible or desirable to ascertain who amongst the rival claimant deserves the office most. My lord, this is all subjective, and government's job is also, my lord, quite, my lord, is to look into it on the whole and to, my lord, finish it. Now, my lord, next, my lord, when it's a question of appointment, suitability cannot be looked into. My lord, 2013 1 SCC, page 501.
Got it.
Para 22. My lord, I'm sorry.
Yes.
My lord, page 515.
Yes.
Co-warranto selection committee. I'm not reading, my lord.
Page 22 says nothing.
Para 22. my
Para
lord.
22 says nothing regarding the argument. This is the argument of the senior counsel.
No, my lord.
Para 22.
My lord, we fully agree with the learned senior counsel for the appellant.
My mistake.
That
Yes.
no, my lord. Otherwise, my lord, it's only
My
we fully agree, my lord. That's that only those
That
words
qualifies the rest.
that qualifies.
I've seen the rest. Yes.
Then, my lord, next is integrity, caliber, qualification. These are, my lord, vague parameters. In a matter like this, I'm not saying, my lord, when there are guidelines put it. In a matter like this, vague parameter 1985 4 SCC 417 paragraph 9. That fourth line, my lord, difficult to see how division bench could have undertaken an inquiry into the question whether chairman, members of the Haryana Public Service when of integrity, caliber, or qualification or not. So long as constitutional legal requirements are fulfilled. That's, my lord, the only thing.
Para 9.
So, yes, my lord, paragraph 9.
Fourth line is it.
Yes, my lord. It starts, my lord. I'll read it, my lord, quickly. It is difficult to see how the division bench of the High Court could possibly undertake an
85
inquiry.
4 SCC. 1985 4 SCC.
Yes, my lord. 417, Justice Bhagwati's judgment, paragraph 9. Thirdly, page 433.
433, yes. 433?
Yes.
Thirdly, yes.
Yes. Thirdly, it is difficult to see how the division bench of the High Court could possibly undertake an inquiry into the question whether the chairman and members of the Haryana Public Service Commission were men of integrity, caliber, and qualification or not. It was a totally irrelevant inquiry because even if they were men lacking in integrity, caliber, and qualification, it would not make their appointments invalid so long as the constitutional legal requirements were fulfilled. That's a, my lord, important factor. Ultimately, my lord, even my lord, co-warranto jurisdiction, I have to show it's legal. If it's in terms of a statute, it has to be in terms of a statute.
Right.
Then, my lord, AIR 1965 Supreme Court 491. Purely on an academic matter. Purely. Courts, my lord, hesitate to express an opinion. AIR 65 Supreme Court 4. Yes. I mean, I didn't get a chance to see yours actually.
Which para?
My lord, para 12. Mr.
You cited this.
Yes. So, my lord, I am not reading it, my lord, again. Para 12 was not cited. Mr. Ali is, my lord, fighter till the end.
No, right.
My lord,
Yeah,
he wants me to read it.
Anyway, I'll just.
My lord, lordship, huh?
Para 12, you see.
What about it? So, my lord, then there's a judgment, my lord, which I want to cite. The Delhi High Court judgment is also a very important judgment. Well, I personally should have checked, my lord, and I will do so. And if I find it, my lord, there's a Supreme Court judgment or it's overruled, I'll come and tell your lordship.
Yes.
Because I am certain this is a judgment which went to Supreme Court. This is reported, my lord, in AIR 1975 Delhi, page 66. Anoni, Lord, I'll just take out the flag marks then.
This was cited before Justice Bhattacharya.
Right. I wasn't there.
Oh, good.
Lord, 75, এটা কি তুমি দেখেছো overruled হয়েছে কিনা? 76, my lord, Delhi, paragraph 5 and 13, my lord. This is very interestingly, Justice Ajit Nath Ray's appointment as the Chief Justice of India challenged before the Delhi High Court. Very peculiar argument made. I must share this, my lord, even though there's little time. The argument was that if I succeed and if the Chief Justiceship is gone, the judgeship also is gone. Because once you become a Chief Justice and you're removed, you can't come back to puny judge. So I think it's goodbye time. All of it was rejected. But, my lord, this is a wonderful judgment on the ambit of, my lord, quo warranto jurisdiction. My lord, please see paragraph 5.
Paragraphs here are not numbered.
I'm sorry, my lord. Lord, may I?
Which page?
My lord, this is page 68 in my book, my lord.
No, 68, no.
Lord, would your lordship, my lord, please take my book? It'll be.
Yes.
I will read from there, my lord.
Please read out from your book.
My lord, paragraph 7 in my book. Before I deal with the points raised, I will state that I understand to be, I will state what I understand to be the scope and ambit of a writ of quo warranto. A writ of quo warranto poses a question to the holder of a public office. In plain English language, the question is, where is your warrant of appointment by which you are holding this office? In its inception in England, such a writ was a writ of right issued on behalf of the crown, requiring a person to show by what authority he exercised his office, franchise, or liberty. Webster's Third New International Dictionary, Volume 2, describes it as a legal proceeding that is brought by state, etc., a purpose similar to the ancient of quo warranto. No, I'm just omitting, my lord. Then, Halsbury, my lord, is quoted. Then the English judgment is
Mr.
quoted.
Chaudhary, please continue reading it. Just ask your Leonard, ask your Leonard Junior to find out the before that.
No, I'll do it, my lord.
No, you continue reading. So let both continue to read.
My lord, I'll read slowly, my lord. My Lord, it's actually tick marked. I'm sorry.
Oh, thank you. Right.
My Lord, please, Halsbury's Law of England is quoted.
Yes.
Then, my Lord, Regina versus Speyer is quoted. 1916 1 King's Bench. Then, which one? Oh, this is in my my learned friend's compilation.
You gave it to court also.
It's in his compilation. Oh no, he's got numerous compilations. What do you want me to read?
Compilations in favor and against.
Yeah, and
Whichever
against. This is in against compilation, which has now come out. So he's not disclosing it. Ki porbo. Miller Halsbury's Law of England. This is what you want me to read. After that, Miller, the leading case in issuing a writ of quo warranto, it is said, an information in the nature of a quo warranto was not issued, and injunction in lieu thereof will not be granted as a matter of course. It is for the discretion of the court to refuse to or grant it according to the facts and circumstances of the case. The court might, in its discretion, decline to grant a quo warranto information where it would be vexatious to do so, or where an information would be futile in its results, or where there was an alternative remedy which was equally appropriate or effective. Leading case on this subject is such and such. Then, my lord,
It could be cured. If you would have that degree or whatever, if you could make good the degree, it could be cured.
It cuts both ways because both ingredients are there. Usurper, public office, these have to be satisfied. That is also there. And you have to satisfy the court that yes, you were appointed correctly. I mean,
yes.
cuts
So,
both
Milord,
ways. Yes.
I'll to cut it. This is Milord. Milord, if one reads it, Milord, earlier judgments are also Supreme Court judgments are noted. Long or short of it is,
Yes.
once this question is put to me by the court, and once I come and show this is my authority, and I show that there is no statutory infraction, court will not go into it further. So my whole argument is this, that when I come and tell your lordship that this is my authority, I am a theologist, I am a scholar, state has considered these are very nebulous and subjective matters.
Yes.
Your lordship will not, in the absence of malafides, will not go into it further. If there is a chance, I succeed. If there is zero chance, I fail. Only one paragraph, paragraph 12 of a judgment at page 350 of his compilation. Milord, he says, Milord, the court says, we are unable to hold on the material. At page 350.
Paragraph
12.
All right.
We are unable to hold on the material placed before the court that the third respondent in WP such and such cannot be treated as a recognized scholar in Islamic theology. This court cannot embark on an inquiry whether such material is sufficient to hold that the third respondent is a scholar in Islamic theology. Suffice it to point out that there is some relevant material on the basis of which the proficiency of the third respondent in Islamic theology could be said to have been established. Now, Milord, in my affidavit, Milord, there is plenty of such material. There are certificates, there are, Milord, participation certificates, there is plenty of material.
Mr. Chaudhary, file a very short written notes of argument, need not be on these legal questions. I mean, you just point out the pages of the affidavits where your credentials are there.
Only one thing, Lord. Those annexures which are my learned friend's affidavit contain, my lord, were never part of the.
Yes, it's an obvious point.
It was never there.
What?
Nobody in the meeting came up and said that these are his credentials. These are after.
These are not also reflected in the decision-making process also.
It's not there.
That's an obvious point, yes.
Yeah, whatever it is there. Well, when should I file my note? If your lordship...
Tomorrow first thing in the morning?
This is... during the winter vacation, your lordship will not write the judgment.
No, I'll pass the judgment after the summer vacation.
But
I've heard
after winter vacation.
Summer vacation.
Summer vacation. So
after the next summer vacation, I'll pass the judgment. But I've concluded the hearing
if your
because
lordship,
your friend was very eager.
Yes, yes, because my lord, it's Supreme Court vacation.
It's a great pleasure, my lord, to appear in this court. My lord, it's my home court, my lord.
My lord, I must
And
tell
my
your
son
lordship.
has now come, my lord. I tell him to
I
stay
don't.
there. The
That's
roots-
always mutual.
the roots
My
are
lord, I
following.
don't grudge him for a minute that he's come, he's argued the matter.
Not my written notes, my lord, may kindly be substituted.
All of you, please file fresh written notes of arguments and write it either the something, give an indication, give the date.
I see.
Give the date when you're filing. Give tomorrow's date and file your written notes of argument, all of you.
I was only hoping to file on the 3rd, but I don't think that's the right thing. But if your lordship writes it during the vacation, I'll
So
file
I
it
won't
tomorrow.
write it because there are other
So then I'll
accumulated.
file it on reopening.
Do that.
Or tomorrow, my lord, whatever your lordship says.
If you can file tomorrow, I'll keep it as to be mentioned tomorrow. Oral hearing,
My lord,
oral
we will
arguments.
do what your lordship says.
No, 9
Your
9th of
lordship, my
August,
lord,
your lordship said file written submission.
I
but
cannot, I mean, immediately after the vacation, I won't be able to pass this judgment because I won't be there most of the vacation.
I see.
And the rest, I am already booked in other CAV matters.
Whatever as per your
So
lordship.
very well on the 3rd, you'll file.
Right,
it.
right. Great,
Oral
my lord.
hearing is concluded in the matter. Full stop for filing of written notes of arguments by the parties. The matter be listed on January 3rd, 2024 at the top of the list under the heading to be mentioned.
Much obliged, my lord.
All of you please file fresh written notes of arguments, compile whatever you have to do and give the date so that I get to know this is the latest.
My lord, I am also going to distinguish my learned friend's judgments in the note.
Do that if you can in the before filing, just exchange between us. If you can.
May I have a
It's come in a scattered form. If they make a paper book, it will help your lordship with an index. Would like to put it.
Yes, what is it?
my lord, may I have a lordship kind leave to mention one matter, my lord? For
Appellate side.
original side, my lord. Original side for leave for obtaining leave to move it before the vacation bench because this is a tender matter, my lord.
Take leave before the vacation bench. There are 2 dates of vacation bench, 27th.
My lord, I intend to move it on 27th. If your lordship so desire, I can come back tomorrow.
No. Take the leave from the vacation bench itself.
My lord, vacation on 27th if I obtain, my lord, tender make it
Come up on 29th.
29th, my lord, will be a bit late, my lord.
What is the date?
My lord, the tender process has been concluded on 15th of December. I came to know from a board meeting of the respondent Kolkata board.
Take leave from the vacation bench. I won't burden the vacation bench.
My lord,
Yes.
item number 2, my lord, that license is going to expire, my lord.
Come
Money
back tomorrow,
acceptance.
whatever happens.
My lord, item number
My lord,
1, my lord, from the original side, my lord. Tomorrow,
May-
my lord, only one prayer, my lord. Tomorrow I will not be here, my lord.
If somebody asks for time, I'll grant time.
My lord, there is
Tell your other side so that they're not.
there is
I am
nobody, my
appearing
lord.
on behalf of the.
There's nobody.
There,
Then I'll dismiss it for you are for the petitioner.
no, I'm the respondent, my lord. I am arguing, my lord. I'm
Who is
ready.
appearing for the petitioner? Tell your learned friend. You remind me tomorrow when I take up.
May I have your lordship's
Late
leave, my lord?
You are appearing for the other side. Item 1. Should I make it after vacation?
After vacation.
It's very urgent matter, my lord.
No.
I'll decide tomorrow.
May I have your lordship's leave? My lord, I appear for the petitioner. This is that matter that Mr. Shah had mentioned yesterday before your lordships, and it was your lordship's kindness that your lordship had.
I'll have to leave immediately. Yes.
Yes, ma'am, my lord. So there's an interim order that has been operating in our
mention
favor,
to
my lord.
My lord, please keep it on the opening, my lord.